1.
Your Lord, I have challenged an order of the Honorable Single Judge where he has dismissed my writ petition challenging an order of the Revisional Authority under the Consolidation Act who had entertained the revision and admitted and remanded the matter after 37 years. Your Lordships had issued notices.
To 225, it's not served yet. It's not come back.
Not come back.
Want to do that's the only way to do it. The notice to response 225 has been returned unserved. No. Sorry. Fresh notice. That's in addition. 11 January.
7 January.
11th.
A copy of the writ appeal may be served on the state. No, we haven't received a copy.
I'll serve.
Great. Item number 2.
Interim order to continue.
Interim order.
Item number 2, my lord, I'm on virtual mode.
Yes.
In item 2, my lord, your Lordship, on last occasion, a directed letter appears. Your Lordship directed to file an affidavit. I said only with short adjournment. Next week, any day, your Lordship may fix it, I'll file it.
Mr. Kuntia seeks the last opportunity to file an affidavit. The affidavit will possibly be filed at least 1 week prior to the next date, rejoined there to penny before the next day.
Let's fix a date relating to pension 80 years old, my lord.
Yes, short adjournment, I'm seeking.
80 years old lady, my lord. 80 years old lady seeking pension.
I know. We'll have it on the opening day, sir.
Any date, but convene to Lordship, because no rejoinder is required, because everything is based on materials on record, which is already on record, my lord. Any date, my lord, convene to Lordship, my lord. I leave the matter to Lordship.
All right, 12th January. Right.
Old matter, item number 3.
Item 3, my lord, this is appeal by the state.
Really?
My lord, delay is 239 days.
Let's do it on that. So delay of 239 days is not properly explained. 484. 484 days.
Sorry, my lord, the officers.
The delay is not condoned. That MC is dismissed. Consequently, the writ appeals. All right.
Item number 4.
I have the petition through VC, my lord.
Yes.
The petition is on Anganwadi workers. Yes, he has challenged the cut-off date for the ACE, my lords. Here, the post is created in the month of September. That is, the advertisement was made on 17/9/2016, my lords. But the cut-off date has been fixed up 8 months prior to that. That is 1/1/2016, my lords. And second, my lords, the gap is gap of 8 months. And yes, my lords. And another thing is, my lords, for other criteria, the date of advertisement is the date for fulfilling the criteria. For other, like the qualification and other ingredients, my lords. But so far as the age is concerned, it has been fixed up to 1/1/2016, my lords. That is more than 8 months prior to the creation of the post, my lords. And the principle decided by the Honorable Supreme Court Amilal Bharat versus State of Rajasthan, my lords, the gap must not be wide. Because it is more than 8 months, my lords.
Let's see what the single judge says, sir.
My lords, the Honorable Single Judge held that this gap is not wide. But my submission in my lords, gap extends to 1 month to 1st of January till 31st of December.
No,
and when it is after.
Do you have any case law which says that it can't be more than 5 months, 6 months?
There is not like that 6 months or 5 months, but the gap is in Amilal Bhatt versus State of Rajasthan, my lords, year 1997 Supreme Court 2964. The gap must not be wide. The principle is gap must not be wide. Wide means, my lord, the gap extends from 1st of January till 31st. So out of 12 months, 8 months has passed. And by that way, but because of that, this petitioner, who is only for a few days lacking to fulfill the criteria for the fill of the age limit, unable to apply, then only one candidate becomes suitable to this post, and it is scheduled tribe. Only one candidate become eligible, and others were not eligible because of this cut-off date.
That's all right, sir. Challenge in the present appeal is to an order dated 2nd January 2017, passed by the learned single judge, dismissing the appellant's writ petition civil 18801 of 2016. Paragraph. The challenge writ petition was to an advertisement dated 17 September 2016, issued by the Child Development Project Officer, bracket CDPO, bracket Kapra Koal, District Bolangir, whereby the age limit of the list of Anganwadi worker, bracket AWW, in respect of the Nandupala Anganwadi Center, bracket AWC, under the advertisement issued on 17 September 2016, was 18 years as on 1/1/2016. Paragraph. Admittedly, the appellant was below 18 years of age as on 1/1/2016, and therefore was not eligible to apply for the post. Paragraph. The submission of learned counsel for the appellant on the basis of the judgment in Amilal Bhatt versus State of Rajasthan, AR 1997, SC 2964, is that the gap between the cutoff date and the date of advertisement was too large, that is more than 8 months, and this was itself a valid ground for quashing the advertisement. Full stop. Paragraph. It is seen that even in Dr. Amilal Bhatt, bracket Supra, the Supreme Court only said that the fixing of a cutoff date for determining the maximum or minimum age for a post should not per se be allowed. Full stop. In the present case, although there may be a gap of 8 months between the cutoff date for determining age and the date of the advertisement, it cannot, as has been observed by the learned single judge, be said to be so arbitrary or unreasonable. Full stop. Moreover, as pointed out by the learned single judge, the advertisement itself was in consonance with the guidelines issued by the CDPO. Indeed, the gap of 8 months cannot per se be said to be unreasonable. But the court is therefore unable to find any ground to interfere with the impugned judgment of the learned single judge. The writ appeal is accordingly dismissed.
Item number 5.
Please, my lord. I am challenging the order dated 8th February 2018, passed by the learned single judge in writ petition number 236669, page number 13, my lord, annexure 1. May I read, my lord?
1 minute. How was this writ petition maintainable, sir?
Yes, that's why I am challenging, my lord.
No, how was the writ petition maintainable against L&T Finance?
My lord, we are for the L&T Finance. I am appearing for the L&T Finance. That's why I am challenging, my lord. And Oryx Auto Finance Limited, it is a citation.
But why have you not got this writ appeal listed in all these years, 4 years?
My lord, I have filed within time.
No, but how has this direction hurt you? What has happened pursuant to the impugned order? Pursuant to the impugned order, what has happened?
They have not filed any contempt proceeding or nothing.
Then why are you worried? We'll just leave the question of law open. Why should you academically decide this? Counsel for the appellant states that nothing has happened pursuant to the impugned order, which granted limited relief to the respondent. Full stop. Not even a contempt petition has been filed. We'll stop in that view of the matter, leaving the question of law open for decision in some other appropriate case. The writ appeal is disposed of.
Item number 6.
No instruction, my lord.
Item 6, sir.
No instructions.
No instruction. my lord.
Sir. Dismiss. So no instructions.
Item number 7.
May I please?
Delay.
Your Lordship, see my limitation petition. Why?
1041.
Your Lordship, see my limitation. Why this appeal has been filed? A similar matter, it arises out of a common order.
Okay, we leave this question of law open here. Sir.
And that writ appeal is pending.
That's all right. We leave it here.
Your Lordship,
Here it's
Your Lordship,
delayed by
for a moment,
1041.
Your Lordship, for a moment, see my limitation petition. Why you have filed? Because out of common order, 2 writ petitions are there. So a question was at the time of hearing that writ appeal, a question was arisen why another writ appeal has not been filed in respect of that order. Your Lordship, see my writ appeal, the limitation. Accordingly, we have filed this writ appeal. Your Lordship can tag this matter along with.
No. How many days is that delayed by?
But that is in time, my lord. The first appeal. Your Lordship, the input order is at page 177. For a moment, Your Lordship. 177. Two orders passing 2 writ petitions. 3027 of 2013 and 1324 of 2011. One writ appeal was filed at 129 of 2016, challenging the order passed in 3027 of 2014. At that point, hearing, my limitation petition, paragraph 4, I have stated. Why I have filed this writ appeal. It can be tagged with that.
No. What has happened, sir? Again, same question. Pursuant to the impugned order, because there's no stay, nothing granted here.
So in that case, 129, that another writ appeal is 129 of 2016 is pending, challenging the same order.
What has happened pursuant to the order?
My lord, I could not get that if that is stated because High Court's website is today, my lord, I could not know what happened in that 129. I'm searching that order.
No. All that was done is
If that has
direction given to the sub-collector to reconsider the
Well,
appointment.
if that has been stated in that 129, it cannot be implemented, my lord. So 129.
When is it coming up? 129.
Yes, both matters can be disposed.
He says it's already disposed of.
Then, my lord, it can be disposed of on the ground of limitation. My lord.
You say leaving the question of law open, the petition is dismissed on the ground of delay, since the inordinate delay for 1084 days remains unexplained.
1041.
And 1041 days remains unexplained.
My lord.
All right.
Item number 8.
Well, it's item number 8 is equivalent. It's a similar road tax matter that has been posted to 5th of December.
All right. List on 5th December.
Item number 9.
So item number 9, this is a matter after disposal of the writ appeal, the review petition was filed. In the review application, another set of lawyer was engaged. Thereafter, remand order has been passed to hear the matter of the appeal. So now I am not in the present case. So my name is there.
All right.
But the
Rajiv since he's no longer hearing the case.
My lord, I am on the review application. I am the counsel in the review application, my lord. And on the order,
Review application.
my lord,
Which review application?
review application 23 of 2022, my lord. And
No, it's not on board.
my lord, that has been disposed of. And pursuant to order passed in that review application, the writ appeal has been restored to file, my lord.
Okay.
Now, my lord, I have instructions to appear, my lord.
All right.
On behalf of the, since, my lord, I could not get the wakalatnama, my lord, I pray some time.
No.
My lord, then I will permitted to place the matter, my lord. Here, my lord, I'm challenging the order dated 21/12/2018, passed in WPC number 172810. I filed the writ appeal, my lord. The case of the writ petitioner is that, my lord, he was working under the board and he got superannuated in the year 1/4/1995, my lord. At the time of retirement, my lord, he got all his retirement benefits that is his contribution and the board's contribution and other retirement benefits, my lord, as there was no pension scheme there. Subsequently, my lord, in the year 1997, can you see the annexure 1 of the REIT appeal, my lord? The board has brought a circular in which, my lord, the pensioners given option to switch over to pension scheme, my lord. That scheme says, my lord, may I read, my lord, that?
Yes, please.
My lord. CPF beneficiaries who
Where are you reading? Just give us a page number.
Page number 9, my lord, annexure 1 of the REIT appeal, my lord, and which is also annexed in the REIT appeal.
Yes.
REIT petition, my lord.
Yes.
Page 9, annexure 1, my lord.
Yes.
CPF beneficiaries who were in service on 1/1/1986 but have since retired and in whose case retirement benefits have already been paid under the CPF scheme will have now option to have their retirement benefits calculated under the pension scheme, provided the refund to the board's contribution to the contributory provident fund and interest thereon drawn by them at the time of settlement of the CPF amount, my lord. So to switch over to the pension scheme, they have to deposit the benefit they have taken, my lord. Subsequently, my lord, this has been extended till 30/12/1997. Annexure 2 and 3, my lord. Thereafter, my lord, the present REIT petitioner, my lord, he has not applied to switch over for the under the pension scheme pursuant to that circular. In the year 2002, my lord, the board has issued a circular in which the board has said the existing pensioners, the pension will not be disbursed through cash counter, and the pension is to be directly remitted to the bank account, my lord. Pursuant to that, my lord, the present REIT petitioner, my lord, annexure, kindly see annexure 4 of the REIT application, page 14, my lord, the application, my lord. He filed an application in the year 2006 after 11 years, my lord. That shows, my lord, may I read the application, my lord?
Yes, yes.
Page 14 of the REIT application.
Yes.
My lord. In terms with the office circular number DLB ACO 7 dated 12/9/2002, I opt for drawing pension through bank, my lord. He has never applied for the pension. And for the first time, when the circular has been issued that henceforth the application, the pensioners will get pension from the through their bank account, for which application has been invited, and in that pro forma he has applied, my lord. The learned single judge, my lord, treating that, my lord, dispose of the REIT application, directing him to give pension.
Let's read the single judge's order, sir.
My lord.
Who's for the other side?
My lord, while dealing this REIT application, my lord, honorable single judge has dealt with a judgment that Sita Goda and my lord, union of others, that fact of that case is different from this, my lord. In that case, my lord, the petitioner, the REIT petitioner there, he was drawing pension, my lord.
It's restored, is it? By referring. Where is it? So who's appearing for the opposite party? The ones who filed the contempt petitions.
My lord, he has appeared in the review application. He has appeared, my lord.
Where is he?
But
This
today-
notice has been issued or not? In fact, notice never went in this.
That this
Writ
writ
appeal
appeal
at all.
disposed of, my lord, on 30/12/2021, my lord.
That's
Thereafter,
right. Between 2019 and 2021,
my lord.
not even notice was issued. The first time it came up for hearing was in 2021.
Your lordship has disposed of the writ appeal on,
When are the contempt petitions coming up?
my lord, on 28/11, it has been fixed.
So you serve him there at least. It is stated that the contempt petition is fixed for hearing on 20th November 2022. Paragraph, the counsel, the appellant is permitted to serve a copy of the present appeal on the sent contempt on it. List on. First February.
Okay.
Item number 10. Weekly list item number 10. Weekly list item number 11.
It is not expired, man.
All right. Counsel to the appellant informs that the appellant is expired. No steps have been taken to substitute by the LRs. The appeal is dismissed as infructuous. Or as having abated, sir.
Item number 12.
May I please, on behalf of Mr. Bose, my lord, matter is infructuous.
Infructuous dismissed.
Item number 13.
I am for the appellant. My application for restoration was rejected on the ground of limitation by the Honorable Single Judge. Therefore, I am filing by this appeal before Lordship. Well, your Lordship may look at the impugned order. My sole submission before my Lord would be the cause described therein are beyond the control of the litigant. Therefore, the learned single judge should have been taken a lenient view in restoring the
What was the
writ
delay?
petition, which was dismissed for non-prosecution.
Yeah, what was the delay?
1000 odd days delay. madam.
Sorry?
1000 odd days delay.
So
1396.
Ah,
1396.
Madam.
missed out 300 more days.
My lord, your lordship may look at the, that is the beyond, my submission would be this. This is the beyond the control of the litigant, and he has approached immediately before the honorable court, and it is a substantive civil right concerning Odisha Land Reform Act. It's a tenant, law ignorant rustic villager. So lordship may leniently considered his application. That would be my submission before my lord.
Right. Lawyers are not farmers. If the lawyer engaged somebody, when the farmer engaged somebody,
You'll just have
after engaging the lawyer, the farmer became unaware, illiterate, poor, everything.
Your lordship may look at
As
here.
long as he engaged the lawyer, there was no problem.
My lord, rejoinder was also filed. Rejoinder was filed.
Then he was not illiterate, poor, nothing.
My lord.
Only when the writ appeal had to be filed, he became all that.
And it is for non-prosecution.
No. So only when the appeal had to be filed, he became poor, illiterate,
My lord.
helpless.
Now, in fact, he is a tenant. If your lordship will look at his property right arises of a Odisha Land Reform Act. The writ petition was concerning to that.
All right.
That would be my submission, my lord, in all.
All right. You see the challenge the
It
present
was beyond the control of the litigant.
challenge the present petition is to an order dated 25th February 2019, whereby the learned single judge declined to condone the delay of 1397 days in filing the restoration application of for restoring OJC number 1999 of 2001, which was non-prosecution on 11/3/2015. Paragraph. The explanation offered by the appellant was that his lawyer did not intimate him of the status of the case, and it is only when he came to inquire about it for some personal work on 4th February 2019 that he became aware of the dismissal of the case for non-prosecution. Paragraph. The learned single judge has that this could not be a sufficient cause. So the delay being more than 3 years would not have been sought to be explained in the above manner, which is not convincing at all. The appellant ought to have followed up the matter periodically with his lawyer to know the current status of the case. Paragraph. Consequently, the court finds no grounds to interfere. The writ appeal is dismissed.
Item number 14.
May I please, Lordship? The present appellant is an assistant professor political science in Sambalpur University. Under Annexure 1, he was issued with a notice to appear in internal complaint committee minutes. I appeared, and on the next date, after it was on 13/11 and on 22/11, directly the order was passed without assigning any regime. If the Lordship will see Odisha University statute.
First, let's see the facts, sir.
What has happened?
What is the order passed? Let's see that.
Order and impugned order of the honorable single judge is passed without issuing notice to the opposite parties.
That's okay, sir. What is
impugned order is Annexure 2. If Lordship kindly come to page 9, that is the impugned order.
Right.
There, if Lordship permit me, I will place. In writing reference to the above, I am to communicate the decision taken by the syndicate by resolution number 190 dated 19/11/2018 for your information and necessary action. You are directed to proceed or leave for 6 months till the investigation is over. Your next annual increment is withheld. You are debarred from all confidential work, including evaluation of answer scripts of the all examinations for a period of 3 years with immediate effect. You are not allowed to visit any hostel or come to the department during the period of investigation. Because this number 2, your next annual increment is withheld. As per section 301 of.
It's only pending investigation, sir. It's not a punishment, not a final punishment.
301 says.
May I submit my sorry for
1 minute, sir. 1 minute. We're still asking him a question, sir.
No, this has been superseded. Only thing that become infructuous. I'm submitting.
Oh, I see.
That is, your Lordship may kindly have a this order has been superseded.
Oh, all right. Charges have been dropped, sir. You say counsel for the respondents is placed on record. Copy of a office order dated 18/10/2021, whereby the earlier resolution dated.
This impugned order has been superseded.
Whereby the impugned order has been superseded and all charges have been dropped against the appellant. Consequently, the writ appeal has become infructuous and is disposed of as such.
Obliged, my lord. Sorry for the interruption.
No.
Item number 15.
May I please, my lord? Page 15, Annexure 5 was the impugned before the Honorable Single Judge, my lord. May I permitted to place the Annexure 5?
No, what about respond number 5? Returned unserved.
Respond 5, my lord, the notice was issued, but the noting is he is out of village, my lord.
Yes.
That is the noting, my lord. But she is never claiming. She is never claiming the family pension, etc. And never made an application before the authority.
So if you have made a party, you have to serve.
My lord.
If she's not a necessary party, don't make her a party. If you have made her a party in the writ petition, right?
My lord, he was made a party in appeal because of the order dated 26/8/2019, my lord.
Right.
My lord, in view of this honorable court's order, and she has been implemented as a party.
Correct. So she has to be served, sir. But service is not complete on her.
Because she is out of village.
Whatever. You have to find out where she is and serve her.
Then, my lord, I'll take again notice, my lord.
All right. Notice to respond to 5 has been returned with the postal remark, open quotation, addressee out of the court. Paragraph, within 4 weeks, the concept of the appellant will furnish to the registry the correct present address of respondent number 5. Thereafter, notice be issued, returnable by speed post.
Some time may be given, my lord.
March.
Item number 16.
May I please, your lordship?
Yes.
Item number 16, my lord. In this matter, I have filed an IA for condonation of 30 days, my lord.
30. Or delays condoned, yes. What's the matter about? So delays condoned, please proceed with the matter.
Yes, my lord. The appellant has filed this case challenging the usurpation of a person who is not entitled to hold that post. Fraudulently, by submitting the fraud certificate, the respondent has usurped a public post who is not entitled to hold that post.
Sir, this respondent number 7 is whom you are challenging, correct?
Yes, my lord.
Opposite party number 7. How old was he in 2018? 2019. How old was he? Are you able to hear us, or are you busy doing something else?
Yes, my lord. I am replying your lordship answer. Lordship query. 59 years, my lord.
So what will be his age now?
Near about 62, my lord.
Will he be still in service?
No.
I think what has happened to this writ appeal? It has become infructuous.
No, my lord.
Why?
If a person who has held the public post and siphoned the public money years together, even after his retirement,
then you go to the Lokayukt, sir. Then go to the Lokayukt. You say the respondent number 5 was already, respondent number 7 is already 59 years old when the writ petition was filed in 2013. Mr. Consul, the appellant admits that he would no longer be in service. Consequently, the court is not inclined to interfere with the impugned order of the learned single judge at this stage.
My lord, before your order, I may be allowed to pray one thing, my lord.
Yes.
The point of law decided in the canon of judgments, fraud has no limitation. Fraud has no limitation.
Fortunately, persons have retirement age.
Even if he has retired from service.
Then you can you have IPC, sir. You have IPC. You can go file a criminal complaint to so many things.
No, my lord.
Yes.
I am in a writ of warrant.
All right.
Item 17.
Yes.
May I please, my lord? May I please, my lords?
Yes, please.
Lords, predecessor in interest of Mahanadi Coalfield Limited, my lord. Western Coalfields Limited made an application for alienation of 103 acres of land in favor of Mahanadi Coalfields Limited for construction of staff quarters, my lord. And my lord, that application was treated as a release application, my lord. And my lord, the lease was processed, my lord, and the matter was placed before the collector for approval. My lord, collector granted sanction, my lord. Thereafter, Mahanadi Coalfields deposited 5 lakhs in towards, my lord, lease premium and went on paying ground rent every year, my lord, up to 2000. In the year 2000, my lord, the Tahsildar issued a notice demanding further amount of 57 lakhs, my lord, which the Mahanadi Coalfields Limited, my lord, objected, my lord. And thereafter, my lord, eviction order was passed. Eviction order was confirmed by the sub-collector and collector, my lord. Thereafter, my lord, we filed the writ petition before Honorable single judge, my lord, honorable single judge, my lord, dismissed the, my lord, the writ petition by the impugned order. Only that since the lease deed has not been executed, we are liable to pay the premium, my lord. My lord, that is contrary to the two judgments, one judgment of this honorable court, my lord. Your lordship may kindly see this judgment. My lord, once a party deposits the premium and my lord, lease has been sanctioned, my lord, execution of lease deed is immaterial, my lord. That this honorable court has held in a judgment relying upon earlier judgment of this honorable court and a judgment of Madras High Court, my lord. Your lordship may kindly come to para 9, my lord. Finding. Para 9 of the judgment. Coming to the merits of the case, I find sufficient force in the contention of Mr. Pal, the learned counsel appearing for the appellant. In the case of Godam Narsama versus Dandasi Naik and others, this court quoted with approval a passage from the decision of the Madras High Court. In the case of Thambi Sampathu Rao, Nainar and others versus Appaswamy Nainar and others, that it would be profitable to extract the said passage here. As regards the land of which government is the owner and which is at their absolute disposal, either because it is assessed to wasteland and estated land or land resumed properties, it is open to the government to make a grant of such land to any person it thinks fit. In such cases, the order granting such land to such persons has the effect of conveying to such person the title of to the land subject to the payment of revenue, etc. Issue of pata ordinarily accompanies, if not follows, such orders, but is not absolute necessary to complete the person's title. Even under the provisions of the circular issued by the government of the year 1961, prescribing the procedure for settlement, I do not find any provision to come to the conclusion that is only after grant of pata, title is conveyed in favor of the grantee.
Sir, even today the lease has not been executed.
Lord, lease deed till today has not been executed because of the pendency of this case, Lord.
Where is the question, sir? Why should that fall? There's no stay of, in fact, the prayer was for execution of the lease. There is no stay granted.
The Honorable Single Judge has given them liberty to apply for settlement of the land dependent on the development of the lease. They should apply for the.
They must have, sir.
That will do, my lord, but the.
You mean you will do what? You have not
because
applied
there
for
is some,
settling the land.
No, application has been made, but this has not been done, my lord.
What has not been done?
Lord, lease deed has not been executed, but demand notice.
What have you done or you are going to do?
Pursuant to the Honorable Single Judge's order, they have not applied. Even after the Honorable Single Judge.
Lord, that part I am not against.
And there are certain legal impediments. What has happened, my lord? So far as this suit land is concerned, this is in Rakhit Khata of government, and there is Gochar land, Patra jungle, and Gramya jungle, Kishan.
So Lord, that forest clearance has been given, my lord.
To some extent, there is some legal restrictions for grant of lease. So those things have to be, let them apply in pursuant to the impugned order, let them apply, the authority will consider in accordance with law, because in the impugned order, which was impugned before the Honorable Single Judge in the writ petition, the consistent view of the revenue authority is that there is no lease deed executed, no advance possession is given, so your possession is unauthorized. And that is why the Honorable Single Judge has said you apply for that will be taken care of by the state government, considering the fact that whether the land in question can be leased out to you or not. That is also the thing which should have been taken into account by the Tahsildar while allowing your lease application. Let him apply, and your lordship can say that if such an application is, it will be taken into consideration, necessary order will be passed within a time-bound manner.
Your lordship may kindly see Annexure 4C, my lord. We have deposited the money at the prevalent rate, my lord. That prevalent per acre, my lord, at that time, 4,000 per acre, and we deposited the amount before the.
My lord, may kindly imagine, the deposit was made in 1970s. When the acre was 4,000, now acre is 4 crores or more than that.
Maybe that by that time we have completed everything, but due to mistake, my lord, that lease deed could be executed. My lord, mistake from either side, I don't know.
Mistake or our mistake, you have not applied. Let them apply, your lordship. We will consider their application. whether they are liable to pay according to the present market value.
No, my lord,
or
that is the problem. We will have
that is the problem. Then if MCL will not pay to state government, then who else can pay? It is not a small organization.
The challenge in the present appeal is to an order dated 25th March 2019, the learned single judge, disposing of writ petition civil number 120 of 2009, filed by the appellant. Full stop. In the writ petition, the appellant had challenged an order dated 25th March 2019. Sorry, had challenged an order dated 30th March 2009, passed by the collector Jharsuguda in Code Revision number 6 of 2007. Whereby
Page 26 of that order. Page 26 of the writ petition.
yeah, it is coming. Whereby it was held that since a formal lease deed had not been executed in favor of the appellant in respect of government land measuring acres 97.790 decimal pertaining to MS Khata number 309 bracket Rakhit of Mozab Rajaraj Nagar town, unit number 3, Jharsuguda, in favor of the appellant, in unauthorized occupation of the said land. Stop. Accordingly, the order passed by the appellate court on 13th February 2007 in encroachment appeal number 1 of 2000 was upheld. Paragraph. Even before the learned single judge, it is apparent that no formal lease deed had been executed in respect to the land in question in favor of the appellate. Consequently, the learned single judge, while noting that there was no scope for interference, permitted the appellate open to apply for settlement of the land dependent on the development of the lease execution of the disputed land involved herein. Unquote. Paragraph. The impugned order was passed on 20th March 2019. Full stop. Even for more than 3 years now, the appellant is yet to make a formal application for execution of a lease.
Lord, perhaps application has been made. I have no definite instruction.
All right. Mr. The counsel, the appellant states he has no definite instruction on whether or not the appellant has even till date, even as of date, applied for execution of a regular lease, execution of a lease in its favor in respect to the land in question. Paragraph. It must be noted here that in the present writ appeal, there has been no interim stay of the impugned order of the learned single judge. Full stop. In other words, there was no impediment in the appellant applying for execution of a regular lease deed in its favor in respect to the land in question. Full stop. Paragraph. Consequently, it is directed that it will be open to the appellant, if not already done, to make an application to the state government not later than 19 December 2022, seeking the execution of the lease in respect to the land in question in its favor. If such application is made, then subject to the appellant complying with all the formalities, the respondent will communicate to the petitioner its decision on such application within a period of 6 weeks, 8 weeks thereafter. And in any event not later than 27th February 2023. Paragraph. Needless to mention that if the appellant is aggrieved by the decision of the respondent, it will be open to the appellant to seek appropriate reasons.
Item number 18.
Lord, what? Any direction to the opposite?
No, to dispose of the application within date.
That is.
Lord, payment, my lord.
Payment part we will take care of that because
Lord, CMD has written a letter to the Chief Secretary. My lord, that remains unanswered, my lord. That is Annexure 4, my lord.
You say in the application,
at page 31.
One can also raise the issue of the premium to be paid.
Yes, let him
for the land in question. Right.
Payment of premium.
That's what.
Okay.
Item number 18.
None appears. So no.
Item number 19.
Same.
Item number 20.
May I please, my lord? Item number 20. Delay in filing, my lord. Delay in 32 days.
Delay is control. 32 days. All right. Control. Yes.
In support of this case, my lord, I would like to file certain documents.
No, you have to tell us what the case is about.
The case, my lord, an encroachment proceeding was initiated. Encroachment case bearing number.
My lord, this is regarding quarter eviction. Honorable Single Judge has directed him to vacate the premise quarter and government quarter and give undertaking. I don't know whether he has complied it or not. Within a period of 2 months, that is by 18th September 2019.
There's no stay granted here.
Not in the quarter, my lord. He is not in the quarter. Encroachment proceeding was initiated. Encroachment proceeding, can it be possible that?
No, you're sure he's not in that quarter anymore?
No, my lord.
Then what is why should we entertain this writ appeal? It's over then. Once you have vacated the quarter, what remains?
Encroachment proceeding, case bearing number 2/15883 was initiated.
Right. That is due to your unauthorized occupation of the government quarter. If you say that I have already vacated it, then that encroachment proceeding has no, because that is not the.
All along, my lord, I am paying the taxes, the fine, etc. charged by the year.
But the counter we have filed that even after the retirement, the petitioner has never, by making a thatched house in the premises, he is still possessing. That is why we have
RI report, etc. are there.
No, is it not correct?
What remains, sir? You vacated the premises.
No, we are not in the premises, my lord.
Same thing, you're shaking your head vigorously, whereas you're agreeing with me. I am saying that you are no longer in the premises. You're saying, no, I'm not in the premises. So I don't know whether you're agreeing or disagreeing with me.
3 decimal of land.
I am saying you are no longer in the premises. Correct?
My lord.
You're agreeing with me?
Yes, my lord. I'm no longer with
That's a good beginning. So if you are no longer in the premises and this is an encroachment case, what remains in the case?
I have been residing in that house since 1969.
I'm not in possession. Then
I'm not holding that. I'm not holding that quarter.
Then what remains?
Quarter or adjacent land. That your lordship may observe that the petitioner submits that he is not in possession of the government quarter or any adjoining government land. Then this.
In government land, I am in occupation.
Yes. That is in the quarter premises.
No, not that.
Then if he is in possession of a government land, how the revenue authorities are wrong in initiating a proceeding?
Anyway, there was no stay. I don't know what you people also did. There was no stay. This writ appeal is now stayed or
No, that he was supposed to file an affidavit. And your lordship may kindly see.
You have helped him continue in possession, sir. There was no stay granted in the writ appeal at any point in time.
We have filed a counter on 8th November 2009.
So what prevented you from evicting him? He has lost in his writ petition. All he was granted is some indulgence of time.
So far as the settlement of the land in his favor is concerned, which he is in unauthorized, we have justified in our counter affidavit that he is a pension holder. His pension is more than 20,000 rupees. So he is not eligible to get he is not a landless person. So that under the OGLS Act, we will settle the land in his favor. That is the counter given. But the impugned order shows regarding only government quarter, but there is an additional prayer that that land should be settled in his favor. What is your case and merits?
What is your case and merits?
That is on merit.
You'll also may call it some other day. I will explain. No. Everything.
No.
So
the challenge in the present writ petition is to an order dated 18 July 2019, passed by the learned single judge. Granting limited relief of permitting the appellant to remain in the premises in question, despite losing in both forums under the OPP (EUO) Act 1971, to vacate the disputed premises within 2 months, subject to filing a paragraph. During the pendency of the present writ appeal, the said order of the learned single judge was not stayed. Full stop. Nevertheless, the appellant appears to have not filed the undertaking as required with the impugned order of the learned single judge. Paragraph. Today, counsel for the appellant claimed that his client is no longer in possession of the premises in question as of now. Paragraph. Mr. Mohanty, learned AGA for the state, refers to the counter affidavit filed by the respondents in the present writ appeal. Pointing out inter alia the appellant had unauthorizedly occupied a government quarter while he was working as staff of the Revenue Department, and continued occupying it even after his transfer to the Housing and Urban Development Department, and even after his retirement from government service. Full stop. Ample opportunity was already granted to the appellant under the OPP (EU) Act 1961. And 45 days time was also given to vacate the land. Full stop. However, the appellant failed to do so. Paragraph. Counsel, the appellant is unable to point out how the appellant could have continued to remain in occupation of a government quarter despite superannuation. Full stop. On merits, therefore, the appellant appears to have no case whatsoever. Full stop. In the circumstances, the impugned order of the learned single judge does not call for any interference. Full stop. There is no merit in the present appeal and it is dismissed as such.
Item number 21.
None appears for the appeal. Dismissal not possible.
Item number 20.
May I plead lordship? My lord. Running page 14 of the writ appeal, the impugned order, I have challenged. Running page 14, 1-4. The
Yes.
order of the Honorable Single Judge.
Yes.
Order dated 26/8/2019. Challenge is made to the order dated 7/6/2016.
So basically, latches. You have to explain why you took 3 years to approach the writ court.
My lord, the petitioner is a woman, a widow, having age up to 82 years. He had a remote and village, my lord. My lord, his property is under peril.
So when the impugned order was passed,
My lord.
you participated in the matter and the impugned order was passed, correct?
My lord.
You were a widow even when the impugned order was passed.
My lord.
So what is the changed circumstance which has prevented you from filing the writ petition? You're not coming for the first time to agitate your rights, sir. You've already gone before the commissioner consolidation. The commissioner consolidation has passed an order adverse to you. So from then onwards, you have to explain. You can't simply say I'm illiterate, poor and all that.
My humble assumption before this honorable court is,
yes,
the woman, the widow.
So when she went before the consolidation commissioner, she was not a widow.
Well, it's my lord.
So she was already aware. See, the question is, if a person has to come for the first time before a forum, we can still say she's unaware and all that. If she's already gone to a forum, invited an order, after that, say unaware is not a convincing explanation.
My lord, the basic her right is existing. My lord, delay may be considered. My lord.
How? You have to give a convincing explanation, then we'll consider it.
The proper right, my lord.
If it's a 3-year delay, you have to convincingly explain, sir.
My lord. I may be permitted to, if they record I may be permitted to amend the writ application, the explaining.
No, not at this stage. Not at this stage. You see, the writ petition filed by the present appellant was dismissed out of the single judge on the ground of unexplained delay and latches of almost 3 years. Of over 3 years in approaching the writ court.
3 years,
challenge and order dated 17 June 2016 passed by the Commissioner Consolidation, Odisha Bhubaneswar, in revision case number 319 of 2010 and 320 of 2010. Paragraph, when asked for an explanation, the learned counsel of the appellant states that the appellant was a widow and therefore was perhaps not aware of legal procedures involved.
Widow and old lady.
Elderly widow. Paragraph, the petitioner's status remained as such even when she approached the commissioner with the aforementioned revision cases. Full stop. Since she herself went in revision before the commissioner and invited an order, she could not claim that she was unaware of either the passing of the order or the consequences of such order. Full stop. Consequently, the court is not satisfied that the explanation offered by the appellant for the inordinate delay in approaching the writ court is acceptable. Full stop. The court therefore also does not find any error having been committed by the learned single judge. The writ appeal is accordingly dismissed.
Item number 23.
Item number 23, my lords. I seek a week short adjournment because, my lords, as per the SR noting, the Wakalatnama is absent and therefore the petition is not cleared of defects. And I sought instructions from the client, my lords. He's recently underwent a surgery. So, my lords, I request.
No, what's the matter about?
My lords, the matter is about about allotment of a home-fed shop. My lords, inside the municipal parking lot, my lords.
How is it surviving, sir? How is this dispute surviving? I don't understand.
My lords.
It's a due to passage of time. The issue is no longer alive. Consequently, the writ appeal is disposed of as having become practice. Right.
My lords, may kindly give me liberty if upon seeking instructions. If
No, sir. That's not it.
Item 24.
May I please, Lordship? May I please? My lord, in between, the financial benefit has been granted to the respondent, my lord.
All right. So it's infructuous.
My lord.
All right. Counsel, the appellant points out that in view of the subsequent developments, the writ appeal has been rendered infructuous. It is disposed of as such.
Item 25.
My lord, maybe, pardon, my lord, maybe adjourned for 2 weeks, my lord.
No.
My
Not
lord, contracting advocate is engaged in standing counsel. He's intimate all his client to take the brief.
When did he get engaged in standing counsel?
He's joined this year, my lord.
This year?
Yeah, lord.
Good. So 11 months are over.
Maybe, pardon.
No, what's the delay?
For the
7 days. All right.
He's intimate all his client to take the brief, but unfortunately this brief is maybe.
It must have been worked out, sir. There's no stay, I think. Okay. It's only a remand. Remitted back to the ADM. There is no stay. The impugned order remits the matter back to the additional district magistrate for a fresh consideration after hearing both parties. There has been no stay of the impugned order during the pendency of the represented appeal. Consequently, the court is of the view that with the impugned order already having been worked out, there's no point, no useful purpose will be in entertaining the writ appeal at this stage. The writ appeal is accordingly dismissed.
Item number 26.
May it please your lordships, I am on this similar. This writ appeal is directed against the order dated 19th November 2019 of the London single judge, rejecting the dismissing the writ petition, which was filed to set aside to book the MSCT award passed by the London Tribunal. The fact of the case is like this. Straight away, I would like to draw your lordship's kind attention to page 13 of my writ appeal.
How is this writ appeal maintainable?
Writ appeal maintainable because the London single judge refused dismissed my writ application, holding that there is alternative remedy available to the appellant.
You're not answering the question, sir. You've challenged an MS award in a writ petition.
Yes.
How is a writ appeal maintainable against that?
Yes, it is maintainable because in view of section 21.
There's a full bench judgment, sir, on this.
Section 21, subsection 2 of the Legal Service Authority Act, which envisages that no appeal against the award of the London Tribunal is maintainable. So no other alternative than to move this honorable court.
No. You filed a writ petition challenging the award.
Yes.
The writ petition has been dismissed by the single judge. How is that maintainable?
Your lordship will appreciate the MSCT matter was disposed of in a low adalat.
That has nothing to do, sir. The impugned order is by the single judge.
Yes. That I may kindly be allowed to place the matter unless your lordship listen to the goes to the root of the matter. Lordship may not accept. The MSCT matter was disposed of in a low adalat subject to certain conditions. The conditions were the compromise will be held good if there is a valid policy and if there is a valid driving license. So on inquiry, it was found that there was no policy at all. So we filed an application before the London Tribunal to revoke that compromise because the conditions of compromise have not been fulfilled. When he refused our application, we moved this honorable court under Article 226 to 27 because there is a bar for appeal. So no other alternative was available to the petitioner. So that is why application was filed, and the Lord Single Judge rejected, saying that appeal is available to the appellant. So that is a very small. This is small question involved in this matter.
All right. The challenge in the present appeal is an order dated 19 November 2019 passed by the Lord Single Judge, disposing of the appellant's OJC number 1938/2002. By pointing out that the appellant, if agreed by the award passed in MSCT case number 31 of 2000, was entitled to file an appeal, regular appeal. Full stop. Paragraph. Having heard learned counsel for the appellant, the court finds the impugn order not to be suffering from any legal infirmity at all. Full stop. In fact, it is even doubtful that the present writ appeal is maintainable against an order, aforementioned order of the learned single judge in a writ petition challenging an award of an MSCT. So, consequently, the court declines to interfere with the impugned award both on maintainability as well as merits. The writ appeal is accordingly dismissed.
Weekly list fresh submission item 27.
None appeals dismissed.
I'm on virtual mode, my lord. I'm appealing. I'm on virtual mode, my lord. I'm appealing, my lord.
All right. In 27.
Yes, my lord. 27.
Yes.
Let's say kindly turn to the order that the review application is filed challenging the order dated 1/2/2010. Let's say kindly get it from page 6, my lord. 7,
Yes.
my lord. The order they available at review petition at page 7.
Yes.
Dr. Sachin Sir, who claims to be petitioner in this case and submits that he has listened his counsel. By this petition, he has prayed to quash the judgment dated such and such passed in TA number such and such by the Odisha Admission Tribunal and the consequential order dated such as passed in MP number such and such. We do not find any infirmity in the impugned order to be interfered with. This is a review. My first submission is, my lord, if I rely on 86 Supreme Court, that the court cannot dismiss, the court cannot dismiss the matter in limine. The court has to give some reason, and thereby a person, a litigant can go and approach the higher forum that this is the reason given by the court below, and let him examine whether. So therefore, if dismiss the matter in limine without expressing any reason, itself is an error on the part of the record below. There must be some reason giving that this is the impugned or the order of the tribunal. This says so, therefore this is we are not inclined to. So my contention is, even if a writ cannot be dismissed in limine, some reason has to be, some reason, some minimum, some reason has to be given.
What is the
my case is for promotion. If your lordship will look at the rule, if your lordship will let's say
your client was already 68 years old.
Yes, ma'am.
In 2010.
Yes, ma'am. But if I get a promotion, I can get the pensionary benefits. That's all. Very limited. I'm working from 88. I'm fighting this litigation from the year 88, my lord. But see, look at. Not, I have no delay, nothing, sir, no laches on my part. Only I will substantiate that the rule provides for promotion. My case was not at all considered. If they will consider, I may get some retirement benefits, some financial benefits. There's a limited price for lordship. The question for consideration is the order passed by the division bench. I think, my lord, my submission would be, this is not in accordance with law because no reason has been assigned whatsoever. It is open to the court to dispose of matter on merit, even absence of a lawyer, that I can consider with a lordship. Suppose Dr. Mahanti could not place the matter, I can understand that. Either adjourn or you pass a speaking order.
Yes, what do you say? The non-speaking order.
Larsen remand.
All right. The short ground on which the review petition has been filed is that the order under review is a non-speaking one. Stop. Indeed, the order under review dated 1st October 2010 gives no reason whatsoever for dismissal of the writ petition, which had been filed to challenge an order dated 13th July 1994 of the Orissa Administrative Tribunal in TA number 132 of 1988 and the consequential order dated 25th November 2004 in MP number 3106 bracket C of 1994. Paragraph in view that view of the matter, while recalling the order dated 1st October 2010, this court restores writ petition civil 1139 of 2009 to file and directs its listing before the roster bench on
Date maybe
21st December.
Oh, that's not.
All right.
Item number 28.
None appears dismissed.
820.
Yes.
Item number 29.
29. In this case, 29. 29. In this case of the present petition recently expired, my lord. I think so. Prefer some time to file substitution petition, my lord.
What's the matter about, sir?
My lord, can you see the, my lord, page 22 of the writ petition, my lord, can you see? The pensioner, some pensioner benefit and the area salary, my lord. Can you see the 22 of tribunal law and tribunal order, my lord? The page 22, my lord.
Yes.
Page 22, paragraph 5. For the reasons indicated above, the original application is allowed, and we direct that the promotion of the applicant to the post of class 2 headmaster, deputy inspector of schools, not eligible from the date of one respondent who was promoted by the annexure 4 dated 28 January 1991. Since the applicant has already retired from his service in the meantime, the pension paper of the applicant shall be revised accordingly, treating the date of his promotion to the post of a class 2 headmaster, deputy inspector of schools with 28/1/1991, and arrear as due admissible be paid to him with from the date of receipt of the copy of this order, my lord. Then, my lord, can see the order of they have challenged the state government challenged the order of the tribunal, my lord. My lord, can see the order of the improvement of this on report, my lord. My lord, the last paragraph after the Dr. has challenged the order dated 16/8/2009 to 16/18/1999 passed by the Orissa Administrative Tribunal, OA number by OA number 3991/91, allowing the opposite party promotion to the respectively. After perusal the order of the tribunal, we do not find any information in the same post interpret with the petition entitled to pensionary. Well, can see the last paragraph. The petitioner is entitled to pensionary benefit of the promotional post, but not the area salary. This is the some irregularity, but not a area salary of the only our limited.
Again, no reason, sir. It's a completely unreasoned order.
Copy they have not served, so I am
already another copy is served today, my lord. Since long,
the office has not marked this as a
since long, my lord.
Department just after
Today I serve another copy, my lord.
All right, copy of the present petition be served on counsel for the MSME department. Paragraph. You say the petitioner the counsel of the appellant informs the court, review petitioner informs the court that the review petitioner is expired. Steps be taken to bring on record his legal representatives.
Well, next week, any day.
30th January.
No, 1 minute. 31st January.
Weekly list item number 30.
Memo is taken on record, not pressed. Dismisses.
Item 31.
May I please? This is a review of the Lordship kindly to of the next sir one is the order, my lord, page 8. Order passed by the division bench, my lord. I am reading, my lord. Page 8 of the review.
Yes, please.
The case of petition that initially he was appointed as a clerk in high school, and then thereafter he promoted to train graduate post, but he is deprived of getting train graduate scale of pay. London Council of School and Arts Department draws the attention of a full bench decision of this court in Krishna Chandra Karnan and State of Orissa, wherein it observed that non-teaching staff are not the employees under the Rule 8(2)(b) of the Education and Recruitment Condition Service of the 94. Hence, a person working as a clerk cannot be adjusted in a teacher. In view of such, the present petition is entitled to get any relief. This is the order, my lord. But that Krishna Chandra case, they are saved us. They are say those person has already been approved prior to judgment. Their case cannot be reopened. This is I have given the judgment perhaps here before your lordship. The two copies of at this type of admission lordship kind. One copy.
This has to go back then. This is the
by virtue of that observation paragraph.
Correct. Review sought in the present petition of an order dated 21st February 2011, passed by this court, declining to entertain the writ petition on the ground that, in terms of the judgment of this court in Krishna Chandra Karna versus State of Orissa, 79/1995 CLT 338, non-teaching members would not be considered a non-teaching member is not an employee under Rule 8(2)(b) of the 1974 rules. Paragraph. Counsel for the petitioner has drawn attention of the court to the aforementioned judgment, which clarifies that those already recruited as staff prior to the date of the judgment could not be affected. So admittedly, the petitioner was already appointed as a clerk.
Approved, my lord. Already approved as 10 graduate teachers by promotion. Their lordship says, judgment कहले those persons are I am sorry, my lord. The judgment said that the clerk non-teaching staff are not eligible for a promotion of the teaching staffs. But saved us, those non-teaching staff already promoted to the teaching staff, right. Their case cannot be reopened again.
Petitioner was
so
already
settled the unsettled position.
As teaching staff prior to the date of the judgment. Stop. Not disputed by counsel for the MSNME department. Consequently, the impugned order.
School and mass education. MSNME department.
No, sorry, SNME department.
Let's kindly see that last paragraph of the judgment. Plus. They are lots of call it. I underlined that.
Right. In that view of the matter, the order dated 21st February 2011 is hereby recalled, and writ petition OGC number 16228 of 1998 is restored to file and is now directed to be listed before the roster bench for hearing on 31st January.
And my one submission, in that time, the matter was heard by the division bench. Now all the matters now before the single judge. So your
All right, roster bench we've said.
Yes, yes. Yes.
Weekly list fresh submission item 32.
Item 32, my lords, appeal is maintainable.
All right. Permitted counsel of the petitioner seeks leave to withdraw the presented petition with liberty to avail the appeal. Remedy if an appeal is provided in the statute in accordance with law.
Well, I'll file a delay honor petition that may be.
If the appeal is filed not later than 19 December 2022, accompanied by
Your
an
Lordship,
application.
Your Lordship, here, the impugned, different orders have been impugned. Your Lordship, for 3 periods, 74, 74, 63, as well as cancellation of registration. So 4 impugned orders have been challenged here, Your Lordship. And on different dates, those orders have been passed and sought.
He anyway wants to withdraw it.
Your Lordship, so far as the condonation of delay, that may be as per rule, Your Lordship.
Yeah.
Your Lordship.
Yeah. Not later than 19 December 2022, accompanied by an application for condonation of delay, citing the pendency of the present petition as a reason for the delay. Then such will be considered on its merits by the appellate body. The court clarifies it is not expressed in view in the matter. The writ petition is disposed of as withdrawn with liberty is prayed for in the above terms.
Item number 33.
May I please, Your Lords? The petition before my lords that the entire assessment order and entire procedure adopted by the service department within the period of a COVID, my lord, and in that period of law, we have also approached the authority to grant some time to submit the documents. That is at annexure 4, my lord. We have already given prior due to COVID, we cannot able to provide all documents. And that part he has also dealt in the order at page 30. They have also given that application. But even though they have a pass order in ex parte matter, my prayer is to the merit of the matter is that it is covered under the mega notification matter. Let the matter be remitted back to the assessing officer. We produce all the documents. Giving any date, I have to produce before.
No, this is an appealable order, sir.
And even if it appeal, my lord, it is passed during the period of a COVID where restriction is there by this honorable court. No order can be passed in adverse to the assessee or persons. But even if the order of the Honorable High Court is there, they have passed the order. So my prayer is to only we produce that notification and the government has to pay. It is the government work order. I am not supposed to pay anything, but if you go to appeal, then paid 7.5%. They have also deal, but after lapse of more than 1 year, they have passed the order. My application dated 11/6/2020 and the order has been passed and dated 3/6/2021 after lapse of 1 year. No notice, nothing.
Who's for the other side? All right. The challenge in the present petition is to an order dated 3rd June 2021, passed by the Assistant Commissioner GST and Central Excise, Cuttack 2 Division, Cuttack. Pursuant to a show cause notice dated 11 November 2019 regarding issued to the petitioner regarding alleged non-payment of service tax. Is 543,178. Paragraph. By the impugned order, the above demand was confirmed and a penalty of equal amount was also levied under Section 78(1) of the Finance Act 1994. Apart from penalties under Sections 77(1) and 2 thereof. Paragraph. The short ground on which the impugned order is assailed is that the petitioner was called upon to produce documents in personal hearing on 11 June 2020, which was during the peak COVID-19 period. And despite the petitioner sending an email praying for time to collect documents, the Assistant Commissioner did not permit such time, closed the case, and passed an order 9 months thereafter on 3rd June 2021. Paragraph, it's not in dispute that the aforementioned period was indeed a peak period of COVID-19, and the request made by the petitioner for time for production of documents appeared to be, and for a personal hearing, appeared to be a reasonable one, which ought to have been allowed by the Assistant Commissioner. Full stop. When court is unable to appreciate the impugned order having been passed, without granting the petitioner such time, and 9 months after closing of the hearing. Full stop. For the aforementioned reasons, the impugned order dated 3rd June 2021 is hereby set aside, and the matter is remanded to the opposite party number 3 Assistant Commissioner to once again consider the case of the petitioner fresh. To start, the petitioner will now, the matter will now be listed before the Assistant Commissioner GST and Central Excise, Cuttack 2 Division, Cuttack, on 16th January 2023, by which date the present petitioner should have filed all the documents sought to be relied upon. And a reply, you have already filed a reply or you have not?
No, he has not filed anything.
Along to the show cause notice. No further time will be granted for that purpose. Full stop. The Assistant Commissioners will then proceed with the matter, and after hearing the petitioner, pass a fresh order, uninfluenced by the earlier order, which has been set aside by this court, within a period of 3 months thereafter. The court clarifies it has not expressed any view on merits.
Name of Mr. Kedia may be reflected. Junior counsel Mr. Kedia name may be reflected.
All right. Petitions disposed of in the above terms.
Item 34.
May I please notes. So I must apologize, my lord, because one prayer was omitted. That is the challenge to the appeal order, and I have not prayed for quashing, my lords. To that effect, my lord, I have filed an IA for amendment, my lords, along with the consolidated prayer, my lords. My humble prayer would be, your lordship may kindly allow the amendment and accept the consolidated prayer portion, my lords. It's only the prayer.
IA number to be numbered. You say for the reason stated therein, the application is allowed, and the proposed amendment in terms of the schedule to the application is permitted to be carried out.
I filed the consolidated prayer portion, my lords. That may kindly be accepted. Page 32 and 33.
Consolidated prayer is taken on record.
Page 32 and 33 may be replaced, my lords. So far as the merit of the case is concerned,
yes,
the challenge is against an appeal order under the GST Act, my lords.
There is no second tribunal.
No second tribunal.
Second appellate tribunal.
And I have paid the entire amount, so there's no question of esteem.
So in the main writ petition, you say the second appellate tribunal has not yet been constituted. The present writ petition is being entertained. Notice he accepts notice. Replies be filed within 8 weeks, rejoined for the next date. And in the IA, you say concept the petitioner points out that the entire.
No, I have not filed any IA minutes.
Concept the petitioner points out that the entire tax amount is already.
Entire penalty amount.
Penalty amount has already been paid. Consequently, no further coercive steps will be taken against the petitioner during the pendency of the writ petition. All right.
Greatly obliged.
8th February.
8th February.
Item 35.
Obligements.
Yes, my lord. My lord, item 35. The petitioner challenges the Annex of 14 series, your lordships, with regard to determination of rate of GST at the rate of 18% on payment of royalty to the state government, your lordships. My lord, in a similar circumstance, similar situation, my lord has already issued notice, your my lord.
All right. Same order.
Lords, I have instructions to appear.
When are these matters coming up?
On 16th of January, my lord.
16th January. All right.
Lords, I have instructions to appear on behalf of the GST department.
Yes.
Respondents 3 and 5, my lords.
All right.
I undertake to file the wakalat now within a week, my lords.
All right.
I'm on behalf of 4 and 6.
All right. Just simply say no coercive action against the petitioner till the next date.
Obliged, my
So
lord.
let's
List on 16 January.
subject to payment of 5%.
They paid to 5%.
Yes, not 5%, if not paid.
If were the question of
Right.
obliged, my lord.
Yeah, all notice, he accepts notice, all that usual, all that is there. It's in the order itself. Yeah.
Item 36.
Notice under section 148 for assessment year 13-14 passed on issued on 31st/3/2021 covered by your lords.
Yes, file appeal, your lordship, see Annex 324. Yes, already challenged the appeal of that, so.
It's all right. It's covered by this order, sir.
No, he has filed the appeal. Appellate authority has filed appeal at page 23. He has already filed appeal. And appeal is pending.
My lord, they are enforcing upon the demand. They are enforcing upon the
No, you
demand
have-
collection. Even
No,
to
you have to move before
this
the
covered
asking
by-
authority. Under 2220.
This notice is very much infructuous. So
No, he could have challenged this.
huge demands.
Once appeal is pending, I think not.
All matters are the same thing.
Yes, same.
Why don't you withdraw the appeal?
I will withdraw the appeals.
This is that. At the outset, counsel for the petitioner states that he undertakes to withdraw the appeal already filed against the impugned order. Dated impugned assessment order dated 29 March 2022. Paragraph, admittedly, the impugned assessment impugned reassessment proceedings are unsustainable in law in view of the order dated 24 January 2022 passed by this court in writ petition civil 20919 of 2021 bracket Messrs. Ambika and Steel Private Limited versus Principal Commissioner of Income Tax, as well as the judgment of the Supreme Court of India in Union of India versus Ashish Agarwal 444 ITR 1 bracket SC. Consequently, the impugned notice dated 1st March 2021 for assessment year 2013-14 is hereby set aside. And all proceedings consequent thereto, including the order impugned herein, are hereby set aside. Then for each matter, the assessment year is different.
Different persons.
Different persons and
yeah, so similar orders in there, separate orders in the other two matters. That's it, right?
Item 36, 37, and 38. Item number 39.
May I please your lordship? My lord, the present petitioner is the licensee of a on-shop, my lord. Lordship will find annexer 1 at page 8. His license was issued by the authority on 1st May 2021 for the period 1st April 2021 to 31st March 2022. But he was allowed to operate, a license was issued on 1st May. For the period of 1st April to 31st April, he had paid the amount, statutory amount. That period was unlicensed period. That annexer 2 is the deposits, my lord, I have made.
Anyway, you've made a representation.
Only annexer 3, in view of 151, either the authority may refund or adjust. I pray for adjust. Let collector be considered that.
Representation will be
yes. taking a view.
Petitioner's representation dated 30th September 2021, bracket annexure 3 will be considered by the collector.
Collector Nayagarh.
And after hearing the petitioner, no, appropriate order shall be passed thereon not later than 6th February 2023.
Collector will refer the matter to the government for referral.
My lord, the ultimate deciding authority is
No, no, my
government.
lord.
The executive part collector cannot do.
Collector will refund after getting approval from the government under Rule 151 of Excise Rule.
Will take an appropriate, pass an appropriate order after referring the matter to the government. Under section 151 of the.
Under Rule 151 of the Orissa Excise Rule 2017.
Under Rule 151 of the Orissa Excise Rules 2017.
He has to recommend, then government has to accord the approval.
Yeah. The exercise be completed within a period of 3 months. No further directions are called for. The petition is disposed of.
Obliged.
Item number 40.
My lord, item number 40, it is regarding waiving of proportionate MGQ for the year 21-22 on the account of closure of shop due to COVID. In the similar matter, your lordship were pleased to issue notice, my lord.
Yes. Bunch of matters have been filed.
The whole batch now coming up.
16th February.
16th February. All right. Notice same order.
My lord, there are also other similar items in today's list.
Yes.
Item number 40, 41, 66, 67, 68, 69. I have provided the list, my lord.
Okay. Same order.
Item number 42.
42, my lords, have given a short synopsis of the issue.
This is shortfall demand on account of AG audit report. Your lordship is remanding all these matters to this the order which.
My lord, the only issue here is I have seen the order that my learned senior had showed me. But it says that it has to go back to the state government, but no authority has been. If it has to be go back to the same authority that has issued the notice, I think that would be
that notice fitted as a notice to the licensee, and license will file so because the government has to take the decision because these matters have to be dealt with by the government. That is the usual order your lordship has passed.
Authority, your lordship must simply say which authority.
That is on account of AG audit report.
Same order can be passed.
Yes, members. Government is secretary.
Your lordship
Secretary is holding court each week.
Secretary in the
The government means secretary. He is holding court twice a week.
Same order. So we've said 23rd November. That's unreasonable now. That we shift that date to 19th December.
From 30th November. My lord, these two dates have to be changed.
That's what.
Yes.
They're changing the date
dates have to be changed.
19th December and 31st December.
Urgent copy of the order on application.
Yes.
Obliged.
Item number 43.
May I please you, my lord? The brief is misplaced somewhere.
Or the petitioner states the brief has been misplaced. The petitioner is accordingly dismissed to non-prosecution to the
my lord.
To revive the petition as and when the brief is located. All right. Yes.
Item 44.
44, 45, 46. Permitted to withdraw.
Dismiss is withdrawn.
Item number 47.
47 and 48, your lordship. Permitted to withdraw, lordship.
Dismiss is withdrawn. 47 and 48.
Item number 49.
None appears dismissed.
Item number 50.
So this is the review petition filed by the may I be permitted to take the file because my file is not
correct.
Only after 10 minutes, your Lord.
All right, pass over. Just give him the file.
We call the next one. Item 51.
51, your lordship, last occasion directed to collect the correct address of the assessee. Lord, we have already corrected, but we are not able to send the notice because the company was changed to another company. We have collected the address, will be permit so that we issue notice. The lordship has already issued notice. We are returned back
That's
because
what?
and just give me permission and all. Lord, we have collected the information that the address of the present.
Mr. Satpathy, learned senior standing counsel for the appellant, now informs the court that the correct address of the respondent has been located and he will supply to the registry forthwith.
Within 3 days.
Within 3 days.
Yes.
All right. Fresh notice be issued on the said address. Returnable 30 January 30. No, 31st January 2023.
Item 52.
52, may I please. This is appeal filed by the department. Your lordship already issued notice. The question is, lordship, see.
All right, you see the in the order dated 17th August 2022, IA number 19 of 19 be shown as IA number 18 of 19. All right. Yes. Has the service been complete in this?
Yes, Lord.
Who's
Only
appearing?
your lordship issue notice.
No, service complete.
Yes, is appearing, Lord.
I'm appearing for the respondents. Today I'm entering appearance in behalf of respondents.
No. So do we admit it? Can we frame the questions?
My lords, ITA number 147 of 2019 as well as ITA number 149 of 2019. Both these matters are identical to the present two matters. And they are posted to 15/3/2023. They are before my lords on 10/11/2022.
All right, list on 15th March 23.
My lords.
All right, list on 15 March 23. Then you put down IA number 18 that exemption is allowed. All right.
146.
No, IA number 19. Put down IA number 19 and see dispensing that application for dispensing is allowed. Correct.
Item number 53.
74 is the same, Lord. 74 is the same that we have posted on 15.
All right. And item 74 is same.
That will start pass the order. We are already lordship issued notice. Exemption has to be allowed.
All right.
Item 53.
None appears dismissed. Memo is taken on record. Dismiss is withdrawn.
For orders item 54. Item number 54.
Item number 54, my lord. We had moved a discuss, my lord. That is 1/888 of 2016, my lord. That was for extending, my lord, some time to complete the tender process. In the meantime, my lord, the tender process has already been completed. Your lordship's order may kindly be seen. That was on 8/12/2015, order number 19, my lord. Paragraph 5 of the order, my lord. We therefore direct the managing director of the Odisha State Medical Corporation to initiate a tender process for procurement of the equipment for the central ICU within a period of 1 week from today. Such tender must be finalized within a period of 4 weeks therefrom, and the equipment must be supplied and installed within a further period of 2 weeks from the date of finalization of the tender process. Report of the compliance must be filed before this court by the Managing Director, Odisha State Medical Corporation, my lord, as well as the superintendent of all the 3 medical colleges of the state. Immediately thereafter, affirming the fact that the equipments have been received, installed, and ICU is made operational. We have the instruction, my lord, that the ICU is already operational.
All right. Counsel appearing for the Odisha State Medical Corporation Limited states that pursuant to the order dated 8th December 2015, the ICU in question is already operational. No further directions are called for the petition's disposal. All right.
Item number 55.
55, my lord, we have filed one IA for additional ground as per the reports shown by the registry. My lord, counter also filed by the opposite party. File a rejoinder, my lord. 3 days time may be given.
IA number 12521 of 2022. The reason stated therein, the application is allowed. The consolidated petition you have to file.
Yes, my lord.
The consolidated petition be filed within a week. The matter you say rejoinder be filed for the next date. Count has already been filed.
Yes, my lord.
Please, list on. Seventh February.
My lord, 7th of
February.
Oh, bless me.
Item number 56.
My lord, I am for the petitioner, my lord. My lord, in this case, the opposite parties are constructing building on the land of Jagannath Mahaprabhu, Vijay Puri, and the government of Odisha without taking any permission from the lawful authorities, my lord. The school has its own land, my lord. Instead, constructing building on the land of government, on the land of school, the opposite parties, without properly examining the feasibility, it's
Any representation is there, sir. Please consider your representation.
The collector.
The petitioner's representation dated 14 September 2022 be considered by the
Collector Baleshwar.
Collector Baleshwar. And after giving the petitioner and the opposite parties 11, is it?
My lords,
Yeah, opposite party 11.
Yes. 4 may also be called. My lords,
Sorry?
It's a temple administration. My lords, since the allegation is that the land belongs to the temple. So
As well as 4, yeah.
Please.
Opposite parties 4 and 11. And after giving them a hearing, a reasoned order shall be passed not later than 13th March 2023.
My lord, I filed the IA, my lord. I filed the IA. They are now continuing the construction work. Till disposal, it may be stayed, my lord.
It will be
disposal,
collector.
it may be stayed.
Yeah, you see, it will be open to the petitioners to request the collector to pass appropriate interim orders pending the completion of the above exercise. The court clarifies it is not expressed any view on the matter.
Right. Item 57.
My lord, item 57 is a PIL matter. My lord. Actually, my lord, opposite pet number 2 acquired some land, village of the petitioners along with other villages for the purpose of, my lord, irrigation project, Suktel irrigation project, my lord. For this purpose, the opposite party have started the process of payment of compensation. Some of the villages are received and some of the villages are not yet received the compensation, my lord.
57, no?
Well,
the representation against
as the representations don't have
my lord,
any
the representation is pending, my lord. Meantime, my lord, they are trying.
What's the proof of dispatch of representation, sir?
Pardon?
Where? The receiving officer.
Representation is, my lord, I annexed
The petitioner's representation bracket annexure 5 shall be considered by the collector, Balangir.
Yes, my lord.
And after giving notice to the petitioners and giving them a hearing. And reasoned order should be passed thereon.
My
Not
lord,
later than
my lord,
13th March
I'll-
2023. And be communicated to the petitioners within a week thereafter. The court clarifies it is not expressed anywhere, but
My lord, today they are trying to forcibly demolish our house without, my lord, without any arrangement, without it land.
there is only an apprehension, sir. Is there anything to show that they're giving you notice for demolition?
Yes, my lord, that is annexure 3, my lord. That is annexure 3. And we have filed a representation annexure 4. my lord.
Annexure 3 is unreadable, sir.
Pardon? Yes, my, this is the only I have.
No, you should file a typed copy then.
My lord, at least your lordship kindly instructed the government state council to.
You should file a typed copy, sir.
Yes, I will file, my lord. My lord, it is the last date, my lord. Your lordship, today they are going to abolish, demolish our entire house, my lord.
Let them go before the collector.
At least, my lord, give some time at least.
So for almost a month now, nothing has happened.
No, my lord. We came from the reliable source, my sir. Date is not there, my lord. But
there is nothing to show that it's being demolished today.
They will only vacate. It's not a demolition notice. It's only a notice for vacating.
Yes, my lord.
Those who have,
My lord, we have no alternate arrangement.
Mr. Counsel, it is written, those who have already received the compensation in respect of that.
Yes, my lord, we have.
They are
my lord,
only to
we
vacate.
pray some, your lordship, I pray some times, my lord, because our house is not prepared yet.
No, but have you received compensation?
Yes, my lord, I admit we have already received the compensation. The land was already identified, the opposite part number 2, but not handed over yet. So it is not possible. How can, this is the winter season, my lord.
In that case, you just say notice. He accepts notice on behalf of opposite parties and prays time for and states that he'll file a reply within 4 weeks, rejoined up for the next date. Paragraph till status quo be maintained as regards possession. List on January 4th.
May I pray, my lord, short prayer, my lord?
In the meanwhile, it will be open to the opposite parties to consider the representation of the petitioners, bracket annexure 5, and pass appropriate orders thereon.
Obliged.
Item 58.
May it please your lordships. Lordship may kindly see Annexure 3 at page 28 to 45. An order of reassessment under section 43 was passed for the period 1/4/2009 to September 2012. Lordship may kindly mark the period. Period is very important here. Now, my lords, I approach this honorable court. This honorable court, Annexure 4, at page 46, it starts and ends on 58, said that the assessment which has been completed, no opportunity of hearing has been afforded. So it was remitted back again to the assessing officer for completing the assessment. And the assessing officer just replaced earlier order, that is Annexure 9, and the same demand which stood earlier was only there.
But anyway, this is appealable, sir.
My lords, appealable. I think my lords may not convict me before trial. That is the lordship may kindly hear me.
Yes, yes.
If your lordship finds that it has some force.
All right.
So that is my only prayer, my lords.
All right.
I should not be hanged before trial, my lords.
All right. You're just sending you to appellate forum, sir. Nobody's hanging you.
The appeal forum itself is hanging, my lords.
No, no.
10% deposit. That itself is hanging. My lords may kindly see.
Yes.
86, same period.
Yes.
What I mean to say, my lords, this period, that is the impugned order of assessment,
yes,
that is 17 to 25, my lords may kindly mark.
Yes.
Kindly notice that the period involved is 11 to 13. And the middle period, that comes to September 2012. Now, reassessment under section 43 again was initiated at the behest of audit objection. I'm just placing 2 lines.
Yes.
The dealer has already been assessed under section 42 of the OVAT Act by the learned STO, Raukla 2 Circle, Panpos, dated 20 February 2014, with assessing a refundable amount of rupees 11,48,881 to the dealer. Consequent upon receipt of the objection raised by the AG audit, where there is allegation of under tax proceeding under section 43 of the OVAT Act has been initiated. The fact of the case in brief is that, as pointed out by the AG audit, that in the month of March 2013, there was an excess carry forward of 1,43,000, which the dealer carried forward to the next month, which the authority did not deduct from the total ITC allowed on total purchase, which resulted in allowing double benefits. So for this 1,43,000, now the entire assessment starting from 2011 again was assessed. That means the assessing officer has gone beyond the AG audit and reassessed it, and a total demand of rupees was again, and without taking my deposits which have been made, he again demanded
37 lakhs 88.
31 lakhs 40,000. So this period, that is from
1st April to 31st March. 1st
yes.
April 2011, 31st March 2015.
Yes, that 2012 again has been reassessed under section 43. Let them, they should have kept that period, and after Mallards, after the assessment under Annex 9 in compliance to the order of this honorable court, I preferred an appeal. Appellate authority reduced it. That also order I have given. I will just now give it. By way of additional affidavit, I am giving it, my lords. And so far as the balance amount, they do tomorrow. Lords, you may kindly.
Now I've heard you.
Beg your pardon, my lords.
Now we have heard you.
Yes. But I am sure, my lords. Your lordship will kindly see that
second round. This is basically second round, sir.
I think this is third round.
Third round. Okay.
Yes,
all
because, my lords, when I challenged the order of assessment, which the assessing officer repeated it, I approached this honorable court.
No. So for the other period, you're already there before the tribunal.
Yes. 561 was filed before this honorable court.
I know.
And this honorable court this time did not allow for second innings. They said, you file an appeal. Accordingly, I filed the appeal. Appellate authority has reduced the demand, and now the matter is pending before the tribunal.
Right.
My respectful submission is, my lord,
yes,
this period from this
11 to 14.
Yes, that 13, September 12 cannot be again be allowed to cannot be again subjected
overlap.
to.
You say there's an overlap.
Yes, overlap.
Wow.
That is the exact malus.
All right. So yes.
And that means Lordship is going to hang me. At least. No. It is the prerogative.
You want to withdraw or we send you?
Malus.
You want to withdraw or should we send you? That's the only question.
Resend malus to the appellate authority.
Yes, obviously.
I thought that your Lordship is sending it to the assessing officer.
Oh, no. To the appellate authority.
No, malus. What my last attempt will be.
Yes.
Can a dealer, I have given one decision I am giving of this honorable court, that there cannot be a repeated audit assessment.
The ground in appeal, sir. That will obviously be the ground in appeal.
Huh?
That will be the ground in appeal. You must have some good grounds in appeal also. We should not deprive you of those grounds.
I will file appeal. I may file appeal.
Yes.
But Lordship may pre-deposit may kindly be, because that is now, that is really difficult.
You have enjoyed 6 years of self-imposed stay now.
Self-imposed.
Since 2015. Your purpose has been served.
Yeah, purpose matters. Actually, what I have been informed that the recovery proceeding is going on.
I see.
That is the whole problem.
Right.
That is the problem. As otherwise, beg your pardon?
Yeah.
Stay.
You pay the 10%, there'll be an automatic.
10% my lords. Lordship will
see. Just imagine 34 lakhs. You put 6% interest for the last 6 years.
As your Lordship pleases. I have no.
All right. You see, counsel for the challenge in the present petition.
May I pray for 15 days, at least 15 days time may be given
to file appeal. That's not a problem.
Yes.
You say, counsel, the petitioner seeks leave to withdraw the present petition with liberty to avail of the statutory remedy of an appeal in accordance with law, if such appeal is filed not later than 19 December, more than 15 days.
Yes.
19 December 2022, accompanied by an application of coordination of delay, citing the pendency of the present petition as the reason for the delay. The appellate authority will consider such application on its merits.
Original annexure that annexure 1 may kindly be returned.
Annexure 1 we returned subject to being substituted with a photocopy, attested photocopy thereof. The court clarifies it is not expressed in view on merits.
Then stay, my lords.
No, it's already there. So, 19 December, that's allowed.
Item 59.
Right.
Obliged.
Right.
May I please know? Here, my lord, I have challenged annexure 1. Here is a case, my lord, the one vigilance authority has detected some issues, my lord, in my premises, and that has been settled, and my case has been accepted by the authorities, and revisional authorities are accepted and directed to refund the penalty amount. And view of the same annexure 1, page 21, they refund the penalty without any interest. That is my challenge, because that I have filed an application before annexure 4 that has not been considered stereotype order has been on the ground, Lord. The act itself silent about the interest, so far as the penalty is concerned. Therefore, my lord, I challenge the legality of this section itself and taking the assistance of the various judgments of Supreme Court, even if there is no scheme of the act or payment of an interest, there should be any compensation because the state has entered the tax since long, Lord.
Long means since how long?
Lord, we have collected in the year 2012, Lord.
2012?
Yes, Your Lordship, CD. The money receipts, Lord, page 30 is the revisional authority. You are before Your Lordship radiated the matter again for reconsider. Even then, my Lord, because of Your Lordship's intervention, my Lord, this has been passed.
All right. You say notice, he accepts notice. This is the first time this petition is coming up.
Your Lordship, first.
All right. No, there are no similar matters.
No, Your Lordship. The provision is very clear, Your Lordship.
Yes, that is what. That's why
it's silent. No, it is silent.
Your Lordship. Your Lordship might have remembered Your Lordship has directed in bunch of cases that Mukund and Mr. Mohanty was arguing in that case. In that case, Your Lordship, the state has filed the modification petition and Your Lordship has directed to pay the interest from the date of deposit, Your Lordship. Even Your Lordship, those bunch of petitions are before Honorable Supreme Court and Honorable Supreme Court has stayed the order of Your Lordship, Your Lordship. So far as this interest...
All right. Notice he accepts notice for the opposite pass. Reply be filed within 4 weeks, rejoined up to the next state.
State has to receive OP1. 1 and 2. 1 and 2 because state is the...
Mr. Mohanty or Mr. So 1 and 2 will be Mr. Mohanty.
3
and 3 to 6
extra
Mr.
copies.
Mishra.
Also.
Replies be filed within 4 weeks, rejoined up to the next. Let's go on. 14th March.
Item number 60.
Please, my lords. My lords, here petitioner challenges the order passed by the first appellate authority under the GST Act, my lords.
Wow. Same. There's no second appellate authority, therefore the petition is being entertained. You pay 10%.
My lord, we have already paid.
No IA is there. Oh, the entire amount have been paid?
Yes. My instruction is that.
All right. Say reply will file within 4 weeks, rejoined up to the next state. And then you see, counsel to the petitioner informs the court that the entire demanded amount has already been paid. That view, the matter no force will be taken against the petitioner during the pendency of the petition. 20th March, 20 March.
Item 61.
My lord, a week's time to rectify defects, my lords.
All right. Defects will be cured within a week, list thereafter. All right.
Item 62.
I pray for 1 week to comply the defects.
All right. Same order, 62. Right.
Item 63.
63, my lord, I've already served a copy. The defect may be ignored, my lords.
All right.
This is a GST appeal, my lords.
Okay. You pay 10%.
20.
Subject to payment, we say counsel to the petitioner informs the court. Basically, you said the petition is being entertained because the second appellate tribunal is not available. Notice, he accepts notice. And in the IA, you see counsel for the petitioner informs the court that 10% of the tax, the mandate has already been paid at the first appellate stage. Full stop. Subject to the petitioner paying 20% of the remaining tax within 4 weeks. No further coercive steps shall be taken against the petitioner. On 20th March, 20 March.
64 and 67, 5 similar matters.
Similar. All right. 64, 67.
Item number 70.
60 to 69.
Item number 70.
Here, under Annexure 3, the Superintendent Excise has recommended to the Commissioner and Government to consider with regard to waiver of MGQ and condition, because your Lordship, shop was closed due to public objection and atrocities act by the public. They have demolished. So, my lord, pursuant to that also I have filed representation. Even then, they have not decided. Under Annexure, my lord, 7 I have.
All right. Petitioner's representation, bracket Annexure 7, should be considered by the Secretary.
Secretary, my lord.
Excise Department. And after hearing the petitioner, reasoned order shall be passed thereon.
When taking into account the recommendation by the opposite party number 4.
Taking into account the recommendation dated 22nd February 2022 of the Superintendent of Excise.
Lord.
Bracket 3. Not later than. February 2022. The decision shall be communicated to the petitioner within a week thereafter. The court clarifies it has not expressed any view on merits. The petition is disposed of.
My lord, we given our opportunity of hearing. I've read
Yes,
also
that I've said.
Lots. Lots. Next item, Lord, permitted to withdraw.
71.
71 permitted to withdraw.
Relief
has been granted.
All right.
Item number 72.
72, Lordship, I'm appearing on behalf of the union. Lordship, we have received information today that the union has already approached the Labour Court under Section 33C2.
This is infractious then. Dismissed as infractious. All right.
Item number 73.
May I please? Lord, here the question is framed, Lord, has not been admitted, but earlier this Honorable directed that on judgment basing on which the tribunal passed order, this Honorable directed to examine whether this is in challenge before the High Court or not. But I am not able to get that because the Andhra Pradesh High Court I am not able to get. But the fact remains, Lord, the issue which has been dealt with by the tribunal, the judgment which are relied upon by the tribunal, it is on the section 94A, but here in 94C, the fact remains, Lord, the joint venture organization and executed one works contract, and thereafter they delegated the subcontract to the 1 or 2% of the.
So the deleting addition of 1,52,000.
No,
what's the tax effect? Tax effect seems to be very minimal, sir.
Yes, Lord. I'm just pressing. Lord, it is more than that. I'm just. It is similar page 40. This is 1120 crores 94,99,540.
No. This particular see that's the overall tax demand.
Yes.
This issue which you're raising, what's the tax effect of that?
I'm just one second.
Because it's only about non-deduction of TDS.
Yes, Lord. That has been disallowed.
That's
and,
what that is only 1,52,104. You want to examine it? You examine the tax effect.
Yes, Lord. I'm failed to examine that.
All right, do that. Use a counsel for the appellant, seek some type of actual tax effect. Vis-a-vis the question sought to be urged. That is request list on 11 January.
Item number 75.
75, Lordship.
I beg to appear for the respondent.
Yes. Here the question is that whether page running appeal memo page 8 deleting whether in the fact and circumstance of the case in law the tribunal is right in deleting the addition made so and so under section 40A IE of the Act for non-objection provision of 194C of the Income Tax Act.
Transmission charges.
Yes. Whether transmission charges come under the purview of 194C or not, that has to be considered by your lordship. And
is it, Mr. Jolly, is it a settled issue or not yet?
Yes, Malaz, there are two High Court decisions, Malaz. The Calcutta High Court and the Rajasthan High Court have taken a view in my favor. Malaz, in fact, what had happened, if Malaz will recall, Malaz sitting in Delhi, there was a decision of Delhi Transco. There, the department had first invoked 194I. Then they changed their track to say transmission is like a technical service. Then they made it under 194J. In this case, they are now saying 194C. It's a works contract. But that also the Calcutta High Court and the Rajasthan High Court have held in my favor. Because my learned friend Mr. Jena is there. He can hand over the copy of the Calcutta High Court decision. I'll take Malod's through that. This is in the case of West Bengal State Electricity Distribution Company. Does Malod have that?
Yes, please.
Yes, Malod. Well, this is a decision, Malod. It's cited in 21786 taxman.com 100. And if Malod will just have the relevant part, in para 3, where the tribunal's findings are recorded. May I read, Malod?
Yes.
The tribunal examined the nature and characteristic of the individual charges and found revenue's interpretation that these charges were for technical services unacceptable. As regards wheeling and transmission charges, which is the case here, the tribunal found we find the payments in respect of so and so. I need not repeat this. Malod will see both sections 194 are considered on line 4, and then Malod's about 8 lines from the top 9 lines. The transmission charges simply constitute. Malod have that?
Yes, yes.
Simply constitute a fee for availing of the transmission utility to be used by open asset concept for distribution of electricity, licenses, and consumer. In our view, the wheeling charges and transmission charges are neither contractual payments nor fee for technical services as contended by revenue, because there's no human intervention or human interface, and therefore this cannot be contractual payment or for technical services. Therefore, we are view there is nothing on record to support the contention of the revenue. Plus, on that basis, and then they follow the Bombay High Court. Because then the matter is taken to the High Court. Because the High Court's findings, if Malod would kindly then have para 8. Malod, the revenue relied upon this decision of the AAR in Ajmer Vidyut Vitran. That's also been overruled by the Rajasthan High Court. There the AAR held against the taxpayer, citing 194J. Then Malod, the final findings, if Malod will see on so the unnumbered copy, but Malod, page 10 of this order. The paragraph starts with this authority has been relied upon by the Karnataka High Court in Gulbarg electricity supply.
Yes, we have that.
Yes, Manoj. Treatment of transmission charges under similar circumstances was found in favor of the assessee in the case of Delhi Transco. Because this is the order I was referring to. Manoj, this dealt with 194J and not 194C.
Right.
Whereas in the case of Maharashtra Electricity Distribution, both transmission charges were found not to be FTS. In all these authorities, honorable benches of respective high courts in some statement found these charges to be similar to that for using a pathway. We concur with the opinions of the different high court contained in these judgments. The reasoning contained in advance ruling ignores the actual character of charges, which in most cases are determined to be statutory instruments. Mr. Saraf has not been able to persuade to take a different view. Such a reasoning, our view, is flawed. And then, Malod, the appeal in para 12 and 13, Malod, the appeal is of the tax department is dismissed. And then, Malod, the Rajasthan view, because Mr. Jaina is carrying a copy of the decision of the Rajasthan High Court in Ajmer Vidyut Vitran, which was the only decision contrary at that point of time. That, Malod, is subsequently overruled by the Honorable High Court.
Yes, that's also here.
Yes, sir. It was a short order, but it considers both 194C and 194J. And then, Malod, there is one more order from the Rajasthan High Court only. In the case of Jaipur, was the Vidyut Vitran Authority. This is an order dated 19th October 2016. my lords have that.
Yes, that's what.
Yes. My lords will see the question of law. The first question of law is the same. The transmission charges, whether they will fall under 194J or 194C. And my lords, that is ultimately, my lords, in paras 7 and 8, the appeal of the revenue is dismissed and then the tribunal of the order is affirmed.
Correct.
So, my lords, this was, in my view, covered by these three decisions.
And these have not been challenged in the Supreme Court.
Well, there is, because I checked the website, it was nothing was showing, but I don't want to make that statement. There is no stay I can confirm, my lords.
Right.
I'll check, my lord. That part only. Otherwise, my lord, I have nothing to say, but I will check whether there is any challenge or not before the Supreme Court, because.
All right. We see counsel for the respondent, Mr. Jolly, learned counsel appearing for the respondent SSC, is placed before the court. Decisions of the High Court of Calcutta and Commission of Income Tax -1 Kolkata versus West Bengal State Electricity Distribution Company Limited, 2017, 86tasman.com, 100 bracket Calcutta, as well as the decision of the Rajasthan High Court, dated 19th October 2016, in DB Income Tax Appeal number 422 of 2011, bracket Commissioner of Income Tax versus people of JVVNL, bracket, both of which hold that payment of transmission charges would not require deduction of tax at source either under section 194 capital C or 194 capital J of the Income Tax Act 1961. Mr. Sampati Learned, standing counsel for the senior standing counsel for the department, seeks time to examine the decisions and make submissions at his request list of 9th January.
Grateful, my lords.
All right.
Item 76.
Yeah. No. Medical waste.
May please your lordship, this is a PIL matter, my lord.
Yes.
Matter relates to disposal of biomedical waste generated in SB Medical College and Hospital, madam.
Correct.
This matter appears today's release as per order number 106 dated 14 September, my lord.
Correct.
I would like to place the relevant portion of the said order if your lordship permits.
Yes. We had asked you to visit.
My lord, that your lordship has already directed the representative of the petitioner to visit the SB Medical College and Hospital as well as other two hospitals,
Burla and
Barampur, madam. In meanwhile, the representative has already visited the SB Medical College and Hospital on 28 September, my lord. And they have inspected the insulator and also verified the documents as was provided by the superintendent SB Medical College and Hospital. After verification and inspection, it is now only I will confine my argument and submission. Only the new and modern insulator has not been installed. That is very clear. And they have also
affidavit, sir.
My lord, I am going to place, I am obliged, my lord. I am going to place that affidavit and a copy of the same also will be handed over. My lord.
See, you have to do it in advance. Only then he can take instructions. Unless you serve it in advance, he can't take instructions, sir.
My lord, today only I have prepared.
I know. So it's okay. You say Mr. Mohanty states that he hands over an affidavit today in court, which is by the Petitioners' representatives who visit, pursuant to their visit to the SCB Medical College and Hospital on 28th September
My lord.
2022. So a copy thereof has been handed over to Mr. Ishwar Mahanti, Additional Standing Counsel to the government, who seeks time for instructions thereon. Paragraph meanwhile, before the next date, the affidavits pursuant to the visits to the other two medical facilities, that is the MKCG Medical College, Berhampur, and Vimsar Burla, will also be filed by the
My only submission before your lordship, as per as
advance copy to
my lord, as far as inspection of Burla and Berhampur, it is very difficult on our part to visit unless the government cooperates. For that reason,
where is the non-cooperation? Unless you,
in fact,
you have to make an allegation of non-cooperation. Only then you can ask them.
My lord, non-cooperation. My submission before your honor, they have to extend some facilities so that we can visit.
Tell us what facility you want.
Want transportation to the place, my lord.
You reach the place, then you will get conveyance.
My lord, from here we have to go, na.
So what's in public interest? You can do this much.
Public
interest, you can do this much, sir.
My lord, my only submission before your lordship, if your lordship directs the state to.
Once you reach there, they will cooperate with you. You reach there and come back.
From here, there is no extension.
All that you can do. You are working in public interest, that much you can do.
For that reason, why I have also given in my affidavit that they not the technical committee may be constituted and they should visit for that two hospitals.
No. We have permitted you to visit. You are making allegations of all sorts. You have to make good the allegation. We are permitting you to collect material for that.
My lord. Then some sufficient time may be allowed so that we can.
Whatever you ask, you tell us which time you want. We'll keep it in February then.
My lord.
Keep it in February or January, whatever time you want.
It may be convenient if it will be fixed to February, my lord.
February, all right. You say list on. February 7th, sir.
Oblige, my lord.
All right. 7th.
And technical, my lord, only submission will a technical person can be assist.
You can carry whomever you want, sir. No,
my lord. Oblige, my lord.
We can list item 77.
It's item 77. I was to take instruction on the upgradation. My lord, the instruction has not come. My lord, give me one chance. This, my lord, pertains to the upgradation of the school for deaf Nuapada. The school has been shifted. The facility has been shifted. Only one issue remained with regard to upgradation to class 10.
Up to class 10.
Yes, my lord. So there was a proposal. I sought for instruction. The instructions.
Okay. At the request of Mr. Mahanti, wants more time for instructions. List on.
Sometime in December, I would be.
16th December.
Grateful.
Item 78.
In 78, I will file the rejoinder affidavit because in their counter they have stated that another writ application was filed by some other persons. And whether that is right or wrong, I will verify and file rejoinder for that 3 weeks time.
No, some road should be recognized as revenue road.
Yes, ma'am. The passage to go to the government road and also the villagers file this writ application.
All right. Rejoinder be filed for the next day. List on. 13th February.
79.
In this case, the government have to file affidavit regarding the status of the road, my lord. Out of 2 kilometer roads, only 300 meters.
Filed a counter. My lord, may sees we have counter affidavit on behalf of opposite party 3, 5, and 7.
No. After that,
filed on 26th of August.
There's a compliance affidavit of opposite party number 4. We got that?
My lord, after that also, your lordship can see 13/7/2022 order.
That's
my lord.
what?
My lord, 13/7/2022 order.
Order.
Yes, my lord. And the order for complete the order is 10/11/2021.
Yeah, to monitor the progress.
Yes.
What has happened so far?
I'll take instruction.
You had said it will be complete. The entire project work would be completed by 9 December.
Please,
So what has happened today? As of today?
I'll take instruction.
Mr. Vanti needs time for instructions. List on 9th December 2022.
Overlay.
1 minute. December. Yes, 9th December. What is that date?
9 December.
9 December.
No, let's not have it on a Friday. 1 minute. List on the immediate afterwards. 13th December.
My lord.
13th December.
Overlay.
Item number 80.
May in this case, today I have filed the rejoinder, my lord. That may come along with the
Copy maybe.
Okay, in construction of some road.
Yes, my lord. Today I have filed the rejoinder, my lord. That may come along with this.
Rejoinder of the petition be placed.
Copy maybe.
Copy to the
13th February.
Item number 81.
May I please your lordship. My lord, this is that IOCL exemption matter, lordship will recall. Sitting Justice Patna, lordship had it twice.
Correct.
Exemption was issued in 2002 in favor of Paradip refinery project.
Right.
And in 2004, 2005, MOUs were signed by Government of Orissa in favor of IOCL that they shall exemptions granted to them in 2002 under the Sales Tax Act and Entry Tax Act will continue for the entire project. Then VAT Act came with effect from 1/4/2005. And on the basis of these government assurances in different MOUs, IOCL held out to all its contractors that they can carry on the work because the exemption continues. Simultaneously, they also continued with the different discussions with the government. Government went on assuring, yes, it will be exempted. And whatever name it may be called, whatever the new act that comes, the old exemptions shall continue. Ultimately, Section 17A, they issued a notification in 2009 giving exemption to IOCL. In the intermagnum period, majority of the works were completed, and under the pressure of the department, they went on deducting money and depositing towards tax. That is the issue in this case, my lord. And our case is based on the saving clause under the new act, and saving all exemptions granted under the previous act.
We'll continue under the new act.
My lords. So in this case, I had prepared to recapitulate. Remember, I have prepared a short note.
Yes, yes.
I'll just place that.
All right. There's already a note that you've given earlier.
Yeah, my same one, my lord. I'll just place a short note.
All right.
That's why I'll place it so that we can recapitulate the facts.
So we'll take it at the end of the board. Just 2 more matters.
My lord. And the lordship will at the husband we are placing southern petrochemicals.
Correct.
Matters exemption.
Right.
My lords.
Right. End of the board.
My lord.
Item 82.
Your lordship, item number 82, your lordship, they have filed the rejoinder, your lordship. The copy of the rejoinder may be served, your lordship.
I will serve my lord in course of the day.
All right. Rejoinder be served on counsel for the state. January 17.
Okay.
Item number 83.
May it please your lordships. My lord, this is going to be 1 o'clock. My experience tells me it's very risky. Good cases are lost. So I'll pray at 2 o'clock.
These matters, my lord, 80. I beg pardon, my lord.
No. What you are saying, I'm already guessing.
I beg pardon.
No. Please wait. Only 1 hour, I'll give you a copy.
Along with, I'm filing it those matters, 83 to 87.
Please.
I'm filing the counter today, my lord, in course of the day.
He has already served.
The copy I'm
He has already served.
along with that, my lord.
2 o'clock.
I prayed 2
o'clock. 2 o'clock.
2 o'clock.
Yes.
This matter is posted tomorrow.
Tomorrow I am
with all the matters.
from the madding crowd.
So Lord, keep it tomorrow.
I am far from the madding crowd.
See how
Lordship may kindly come with refresh.
All right.
Greatly obliged, my lord.
2 o'clock. Pardon me, my learned friend.
2 o'clock will take it.
My learned friend is the leader of the madding crowd. Just it had to
He's taking his chance.
Leader is very dangerous. Better to be a disciple.
88. So 84 also.
Yes, there are 5 matters.
83 to 87.
5 my lords.
All right. 2 o'clock. Okay.
Number 88. That may be taken up tomorrow. I am filing counter today.
2 o'clock. Please cover matter. I'll show how it is covered.
All right.
Very recent lordship have delivered the judgment.
All right.
That only lasts to lead. Totally covers.
Let's see. All right.
Item number 88.
Much obliged.
88.
Item number 88.
Become infructuous.
Yeah, none appears dismissed. All right.
Item number 89.
89, I have filed the counter today.
The reply stated to have been filed with the state be brought on record, adjourned to be filed for the next date. List on.
I have already filed in hard copy. I have filed.
All right. 20th February.
90 also, Your Lordships. I'm there with Mr. Ray. Can you come after lunch?
Yes, after recess. My learned sister is there. 90 ballots. Their lordship have given earlier last date to the department. Then last date after last date, last date after last date. Today it has come. And we are lucky enough that the matter has been listed before lordship. And
last date what
last date thila. Tapare puni apon nele time before justice court number.
No. Last of the lordship, Justice Singh and Justice Raman has directed to file an affidavit stating
before that.
Late to complete, sir. Why you are obstructing always?
Yes.
Right.
My lord, that review matter, I have checked it off. No merit.
Item 90 is passing.
Item 50.
No, 1 minute. 90 wants to say something.
So this lordship directed to file an affidavit whether this case relied upon by the tribunal is similar to this affidavit or it was challenged before the High Court under 260. Lord, I have not get the checked. I've checked out, Lord. I'm not able to find out whether it is challenged. But however, Lord, the issue which has been dealt with by the tribunal basing on the judgment of the earlier order was passed, that is not similar to this. I can distinguish not.
All right. So 2 o'clock.
So that affidavit I'm just filing, Lord, now in compliance to that order.
All right. So filing, that's fine. Then we'll take it up at 2 o'clock.
Your Lordship.
All right.
Item 50. That review matter. Lordship can dispose it.
You say no grounds made out for review. Review petitions.
There are
I think there are 2 reviews.
Well, 2 review petitions.
Correct. Both. So we'll come back at 2 o'clock.
And 21. The accused, it is a NDPS case. The accused in custody, 7/11/20. And accused only male member in his house. And accused a 9-year-old daughter, ill, my lord. The rheumatoid heart disease. At Fulbani. And my lord, the X-ray report here, my lord. And see, X-ray report.
Not sir, please. We have to ask instructions. I am not a doctor. You can't show it to me.
As Mr. Katkia had taken time for instruction, my lords. I had called Mr. Katkia. I think he's stuck in another court. My lords, may
I can't be sitting only for this, please.
I'm extremely sorry, my lords.
Please ask him to come. Tell him I'm waiting.
Yes, my lords. Yes, my lords.
Where is the doctor's certificate fixing a date for surgery?
Surgery not fixed, my lord.
Ah.
Because he is a male member, only one male member in his house. He is a custody. So 9-year daughter, my lord.
So you have to show us some medical certificate recommending surgery. Where is that?
Surgery is not decided, my lord.
No. There must be a certificate which recommends surgery.
Recommend surgery is the Pulwani, my lord.
Oh, sorry, I was held up in another court.
No, tell me.
Well, actually, I have not received any instruction from the IAC. I was, of course, desperately trying to get it today by 10:30. By now, I have not received any instruction. On the last occasion, he has misled the court. And he has filed one affidavit, he has filed one document which was fake. Probably that has been noted.
No, that was earlier. This time
Earlier, a fake document was produced. And here is a case where close 102 kg of ganja has been seized. This person was caught red-handed.
Anyway, you find out about this is about his daughter's medical condition.
His daughter, my medical
Mr. Katkia seeks some more time for instructions. We'll have it on Friday then.
Yes, ma'am.
Friday. All right.
Lords, with due respect. Urgent matter, my lords, I'm mentioning.
It's odd to see you in person.
Actually, my lords, a single bench criminal appeal.
Right.
Justice Sahu had granted interim bail.
Okay.
Now the bench has changed. I made a mention before his lordship on Thursday for extension.
Okay.
His lordship said it has to go to the assigned bench.
Ah.
So I made a mention before Justice S.K. Misra on Friday. His lordship directed it to be taken up today. But it was not listed because of the fact that interim order had been granted by Justice Sahu.
Oh.
So Justice Misra told me to make a mention before your lordship.
All right.
The urgency is he is due to surrender today.
Today.
So the IA will become infructuous.
Oh.
Records are all ready.
Okay, you say list today before Justice Mishra. Just take that. List today before Justice Mishra.
Much obliged.
Weekly list item number 83.
18.
May it please the Lord. For the assessment year 16-17, an assessment under section 143, bracketed 3, on the annexer 1 at page 11 was completed. A demand was raised. I filed appeal. Memo of appeal is also annexed 2. Now, in the meantime, alerts, proceeding under section, the procedure under section 148A A was
started.
I gave the reply. Then my lordship will be pleased to see the order which has been passed under section 148A and the notice in form number 148. As a consequence of 148A, they have to give a notice. Lordship, I'll just place the order how prejudiced and a biased manner 148A has been passed. Just your lordships to the relevant portion. Lordship, I'll just take your lordships to page 22, the last paragraph of the order which has been passed under section 148A. The allegation is, I did not deduct TDS to the amount of tune of rupees 15 lakhs. Now, what the officer did, the assessee failed to furnish any explanation or submit any documentary evidence regarding non-deduction of TDS for payment of interest on deposit of rupees so and so, the assessment year 16-17. Hence, rupees 15,19,719 needs to be disallowed. And before awaiting a reassessment to be completed, reassessment has to be made under section 148 in the line of the procedure. Either faces that has to be 143 2 notice, 142 1 notice, then questionnaire. Then when he directly decides, I am disallowing this. So what is the meaning?
No. Needs to be disallowed has to be understood as what his view is. It's not the final decision. See, the way we interpret, the way we read the sentence, that needs to be disallowed, this is opinion. We treat it as his prima
Needs
facie.
to be disallowed. As in,
we'll treat it as his prima facie.
No. Lordship, may kindly see the next line. Accordingly, the transaction of rupees 15,19,719 is remain unexplained in spite of opportunity being hard granted to the assessee during the present proceeding.
All of this is only the proper notice. See, under 148A D, he has to anyway form an opinion.
So
the opinion is very informed.
That opinion, my lords, Lordship, I'll take your lordships to the section. What happened after 142021? The same thing has been considered in the regular assessment under Annexure 1 of the assessment order, scrutiny assessment. The same thing has been considered. And a demand was raised for which I filed an appeal. Now, after the new provision came into force, I have been noticed under section 148A(b), and thereafter I filed my reply. Reply has been filed, and he makes an opinion that yes.
Because the first word in 148A(d) is decide. So that this is the decision. And it can only be a prima facie decision pending the adjudication on the 148 notice.
Well, now, is it permissible in view of the decision of the Supreme Court in Oryx Fisheries case that the so-called notice should not be in a biased and a predetermined manner, which has been followed by your lordships? Now, lordship will see the information. 147 has been discernibly changed, and 147.
The word is suggest now. The word now is suggest.
No, my lords, I'm sorry, my lords, I may be incorrect also. That also. The first is 147. May I take your lordship to the language of 147?
Yes.
If any income chargeable to tax in the case of the assessee, has escaped assessment for any assessment year, the AO may, subject to the provisions of section 148 to 153, assess or reassess such income or recompute the loss or the depreciation, so and so, or any other allowance or deduction for such assessment year. Hereinafter, in this section and section 148 to 153, referred to as the relevant assessment year.
So
then, my lords.
So the reason to believe has been removed.
Reason? No, it has not been. It is the reason to believe so as to say that it has been completely obliterated from the statute. I cannot say that that interpretation is not correct. My lords, lordship may kindly see the section 148. Before making the assessment, reassessment and recomputation under section 147 and subject to the provisions of section 148 capital A, the assessing officer shall serve on the assessee a notice along with a copy of the order passed if required under clause D of section 148A. If required, require him to furnish within such time period as may be specified in such notices, return of his income or the income. The proviso is more important. Provided that no notice under this section shall be issued unless there is information with the AO which suggests that income chargeable to tax has escaped assessment. Now, there should be a cogent information. Here, my lords, the information is of the AG audit. I will take your lordship to the decision of the Eastern India newspapers case, 119 ITR by Justice Pathak, my lords, where the Supreme Court said that the reopening cannot be made by an AG audit. I'll give. Sorry. Lordship, may I kindly see the platform. Reassessment, information, held view of internal audit party of the department that certain income already assessed ought to have been assessed as income from property and not as income from business does not constitute such information. Here, my lords, besides the AG audit, there is no other information. No other information. And now I'll take your lordships to the legislative history of this 147. This law came on 142021. Now, lordship has to examine what was the law before that date and what mischief was intended by the parliament to remove it. So, देखिए, yeah. Under night, oh, I would have copied now. My lords will kindly see. This is number one. I've given the legislative history. Under the 1922 Act, there was section 34 for charging income tax which has escaped income.
Right.
There was no provision to issue any notice. In the same section, the assessing officer will give a notice. And it continued till 1957. Then there was a Tax Law Amendment Act, where 34(1)(a), 34(1)(b) was substituted, which gave the authorized the assessing officer to issue notice. Then 1961 came, and your lordship is aware of that notice has to be given. One is subject to limitation. 149 is the limitation subject to approval under section 151. All these things were incorporated. Then Tax Law Amendment Act 1988 came, and again there was a radical change with effect from 1489. That also I have given it. Now, in that 1489 Act, the first proviso was introduced. Second proviso was introduced where the matter is in appeal. And first proviso is after within 4 years, not beyond 6 years. That was there. Certain very, which is available to the assessee as well as to the department to be cautious about the escapement to tax the escape income was there, was introduced. Now again the legislature felt after, and this has been also reflected in Ashish Kumar Aurala's case about the aim and object of this. Briefly, the lordship have said that why, that because of the multifarious litigation that GK and Driven-Shaft and the change of opinion, which has given multifarious litigations. So therefore, as a result, that it must be to the benefit of, to the assessee, which will be a balancing one, to the assessee as well as to the public, public interest, public revenue, or so it may be matters. So this came in 142021. What I mean to say, my lords, earlier, the law was.
No, I think one major thing which you probably missed out in your narration is GK and drive shafts.
GK and Driven-Shaft, that was the major.
So one
yes,
major development is GK and drive shafts, which has now become statutory. By this whole scheme of 148A.
Yes. That's correct, man. Yes. Now the question is, what I am trying to explain to my lords is this, that the limitation, which was earlier was 4 years to maximum 6 years.
Now it's 10.
Now it has been limited to 3 years.
And
to maximum 10 years. Okay, my lords, if I'm correct or not?
Of course.
Yes. Then, my lords, and it is again subjected to
give you more hearing and give you more misery.
Thank you. Thank you. Now, no, it is a great privilege to argue before my lord, because so far as my knowledge goes.
No, it's like this. There are so many holes in the tank. Okay, you're starting to plug. The legislature says, okay, let us plug this. Let's plug that. Okay. Meanwhile, the lawyers are creating other holes. Yes.
Now, my lords, it is now also this limitation 3 years, which has been reduced from 6 years to 3 years, it is again subjected to another limitation. That is, Lordship may kindly read 149B.
Yes.
And also the first proviso.
Right.
If 3 years.
Yes.
But not more than 10 years.
Yes.
Have lapsed. So the maximum period is 10 years.
Right.
Have elapsed from the end of the relevant assessment year unless the AO has in his possession books of accounts or other documents or evidence which viewed that the income chargeable to tax represented in the form of asset which has escaped assessment amounts to or is likely to amount to 50 lakhs. This is the first limitation.
Correct.
If you want to open, you should have the evidence that it is in the form of the asset and it is more than 50 lakhs. Provides the first provision which carves out from the main provision. It is like that, like this. Provided that no notice under section 148 shall be issued at any time in a case for the relevant assessment year beginning on or before 1st day of April 2001 if such notice could not have been issued. Lordship may mark the language of the legislature, could not have been issued at that time on account of being beyond the time limit specified. This was not there, my lords, in the earlier provision. In order to remove that mischief, Lordship knows the hidden rule. And the first case is Bengal immunity versus State of Bihar. There are other judgments also. It's very common that what was the law before and what the legislature intended to remove that.
Correct.
My lords, the arbitrary power of the assessing officer to reopen the assessment already completed under section 143(3) has been carved down. As suppose the assessing officer goes to the market or say to a mall and hears that so and so assessee has solely a piece of land or a motor car and he has got the return income, received the payment, and are not reflected. But on that basis, he reopens. So therefore, my lords, the decision of CIT versus Lakshmi Mewal Das that the information should not be made as a gossip. Here, my lords, your lordship have seen the judgment of the Supreme Court that Eastern India newspapers case.
Even an audit report is not.
Yes. That cannot be the basis of reopening the assessment. And secondly, my lords, all these things, all this procedure is dependent on the limitation. You cannot brush aside the limitation. And the assessment here is 1617. And the notice they have given is in 2022, which
So
is
it's between 3 and 10.
yes.
Between 3 and 10. So this B is straight away there.
B is straight away there.
Correct.
B has been also issued.
So then we'll have to start interpreting the words other documents.
Other documents.
Whether the word other documents includes an audit report.
Yes. Other documents.
Yeah.
Yes.
So all that, even that Eastern newspaper will have to
From
be.
the end of the
Because
relevant
Eastern newspaper was under the older statute, reason to believe.
Reason to believe.
The whole discussion in Eastern newspaper is around reason to believe.
Now, what my purpose is, my lords, that AG audit cannot be that report or any objection.
We don't know. I'm saying that will have to be interpreted.
Yes.
The word other documents
that is
includes
limited,
AG report or not. Because the word is not information.
Information. Information is, my lords.
Information is only in 147.
No, not in 147, my lords. That is in 148.
Okay.
Yes.
148.
I am sorry, my lords. Let me again check up. Shall serve the associate notice. I'm just now read it. Just a minute, my lords. Provided, yes. Provided 148 proviso, my lords. No notice under this section is issued
unless there is information.
Unless there is information with the AO which suggests that the income chargeable to tax has escaped assessment in the case of the assessee. For the relevant...
Now look at this explanation 2, which is very interesting.
That is regarding such.
No. Explanation 2 under that itself. Under explanation 1, explanation 1, Roman small 2.
Roman small. Any that I have also marked it, I could have brought to the notice of my lords. Any final objection.
No, that was the earlier thing.
Beg your pardon?
Yeah. Now, with effect from 1/4/22, it's become an audit objection.
Now, this is, my lords. This has been, my lords.
Any audit objection
to the effect that the assessment.
Lordship knows CIT versus India navigation. Any statute of the Income Tax Act which comes into force with effect from 1/4/2022. 2021. I'm sorry, my lords. This will apply to the financial year that is 1920.
Right.
That is CIT versus India navigation, 41 ITR. And the second is Chaudhary Transport by the Supreme Court. And the Lordship overruled the decision. Any amendment brought after 1/4 April will not affect it will apply subsequently.
All right.
So, 1/4/2021, this came.
Correct. Any final objection raised by the
Yes. So, this came with effect from 1/4/2021.
Right.
Now, the information which has been given by the audit party is audit, AG audit or any audit objection that TDS to the tune of rupees 15 lakhs has not been deducted. So therefore, reopening. Or basing on that AG audit, they have reopened the assessment. Now the question is, my lords, all these things are dependent. I'm again repeating, my lords, are dependent on limitation.
Right.
Because on the other day, on last Thursday, I have brought to your lordship's kind notice of 2 judgments of the Honorable Supreme Court. One in commercial motors, judgment at the another it is Tirumalai Chemicals, where their lordship said that to plead limitation is also a right. So, my lords, unless, and that is in the notice or in the order sheet. I'm not able to, of course, I'm not been able to get the order sheet. That the assessee has concealed, or the income of the assessee has escaped assessment is more than
50 lakhs
in the form of the asset to the amount of rupees 50 lakhs.
So yours is less than 50 lakhs in your case.
Yes. This reopening is also subject to limitation. You can exercise limitation. Limitation is also there for both the parties, for the assessee as well as for the department.
So if it is between 3 and 10, it has to be more than 50 lakhs.
Yes, 3 and 10, it has to be 50 lakhs. When you are going to, you can, this is the, Lordship will kindly appreciate. This particular was brought with an intention that prior to which the limitation under section 149 was there, the 4 years and 6 years was there. So now the limitation earlier 149 has been replaced, has been repealed by a new provision, that is 149, with effect from 142021, which applies to the financial year 2021. Now, my lords, Lordship, may I again trouble your Lordship by bringing the two judgments of commercial motors, which earlier I have shown.
No, that is to which financial year it applies?
No, that is India navigation.
Right.
It is about the limitation. The right to plead limitation
is itself a right.
Is itself is a right.
Right.
And both the parties, for the assessee, just to my satisfaction. Now I think I am clear on the, or if any doubt is there, I'll go another 5 minutes, I'll take your Lordships. Then I'll summarize it. I guess that your Lordship, so far as the violation of rules of natural justice, that it's a...
Yes. Correct. Yes.
Lordship, it appears that Lordship is not appreciating so far as Oryx Fisheries Private. What I gather is my impression, because
no, we are waiting for you to reach the Punjab and Haryana High Court.
Yes, I'll definitely, my lords. No, definitely, and also yes,
that's right.
What Punjab Haryana High Court did, my lords, what was challenged?
Yes.
What was challenged?
Yes.
An order under section 141D. Okay.
148A.
Sorry. B. 148A, capital A, D.
D.
Very good.
1D.
That judgment is totally distinguishable. There was no challenge with regard to the mandate.
Now you're making everyone sitting behind nervous.
Beg your pardon?
You're making all of them sitting behind nervous.
No. They are stalwarts.
Because they were waiting for tomorrow.
Who?
To see what we are going to say and all this. And today, if you are making us say it, then what will they have?
High Court judgment today will be demolished. I am determined to demolish it. And first,
it's called doctrine of merger. So that's a
merger.
Yes.
My lord knows that in an All India statute, any High Court gives a decision.
No, it is merged in the order of the Supreme Court. That's the problem you have.
No, that's the problem. I welcome that decision. Very much welcome. And Supreme Court rightly has dismissed it. Why I'm telling my lord?
All right.
Lordship knows the decision of the Supreme Court.
Yes.
64 Supreme Court, that went also from Odisha. That you cannot apply any judgment of the Supreme Court. That some Misra versus I'm forgetting because of my age. Earlier I used to remember each para and now I'm not, huh? Yes. Yes, logical that my learned sister, she is able to get it. Now, my lords, I welcome the decision of the Supreme Court. Why I am saying?
Let's see. In fact, let's see the Punjab and Haryana judgment. You have the copy of the judgment?
I had, but I have kept it for tomorrow. I am not. I kept it. I have the judgment of this.
Today, we'll take today as a rehearsal.
Huh?
We'll take today as a rehearsal.
Your lordship pleases. So, Acha, then your lordship is keeping it tomorrow, I think. But
Mr. Kar is really heaving a sigh of relief to hear you say that.
Beg your pardon?
Mr. Kar is really heaving a sigh of relief to hear you say that.
Now, he is also equally very much equipped counsel. My lords, then...
No, because this whole discussion will be incomplete without that. That's why.
Yes, yes. Definitely. Eta uchi. Eta diontu mote Sri Metallics. Tarini, Tarini. May I, then your lordship may kindly see item 85.
Right.
WPC 23354 of 2022.
Yes.
A so-called notice was issued. That day, I was incorrect. Definitely, and I'm saying it. I was incorrect in not reading that 148A(d). I missed a part. I don't know because of
no, it's all right. It happens.
My age or something like.
Yes.
Now, my lords, lordship may kindly see so-called notice.
Yes.
Annexure 1 at page 10. Date is 31st of May 2022.
Correct.
Okay.
Correct.
Now, my lords, reply given. The next annexure 2 and the copy of the proceeding 2/A 13 and 27.
And the order is 29/8.
Yes.
So here you have a point.
My lords, 29/8.
Correct.
29/8. Now, my lords, count affidavit, and here your lordship have to call for the records. What they have said.
I don't have the counter response. See the paperwork unless if not scanned.
Lordship may kindly turn to page 4 of the counter affidavit. The assessee has filed time petition on 16/6/2022. Accordingly, time was allowed for compliance 16/7. In between, assessee filed his reply on 28/6. Lordship may kindly see that. 28/6, I filed my reply. Further, assessee was given final opportunity. I don't understand it. Your lordship kept the issue whether an opportunity of hearing is necessary under section 148A, capital A and small b. Now the assessing officer says, I have given you final opportunity of hearing. Whether there was any notice to that effect, whether there was any participation, whether the order said the assessee has to put a signature, that is not there. They have not enclosed it.
The reply in this is not there in order.
No.
No, 1 minute. You read out from a reply.
My lord.
Copy is not with us.
Yes, my lord.
You have another copy.
Yes, my lord.
23354.
Only one copy, my lord, the original copy.
Lordship may take up also my counter affidavit. Hey, sorry, they are counter affidavit.
That's why we're asking for it.
Yes.
Because it's not in our paper book. No, it's okay. We can share this. Don't worry.
Page 4, my lords.
Yes.
Page 4 of the affidavit.
Yes. Yes.
The assessee has filed time petition on 16/6/2022.
No. No, you've given us wrong counter, sir. 23354.
23354.
Yeah, he's given us three metallics.
Sir, I'm giving handing. I have also, for lordship's convenience, I have red marked it.
Time petition, and accordingly time was allowed for compliance by. But the rest is given final opportunity.
Yes.
Oh, and then you filed a reply on 24/8.
No, I have not filed. I have not filed. If I have filed a reply, then why don't you enclose it?
Right. He's not filed anything.
I have, how many times a reply will be given?
Yeah. So once he's filed it on 28/6, so then 1 month from the end of the month has to be.
So therefore, my lords, yes.
So it has to be 31st July.
Yes.
Point made. Unless subject to what he says.
No, he has to demonstrate it.
Yeah.
By producing the records and with an additional affidavit.
Good back.
Then I see metallics.
87. No, Tarini automators.
Yes.
Mr. Mahapatra, you understood the point, right?
Yes, my lord. Opportunity was given.
No. It's about the within from end of the month, within
Yes, my lord.
1 month.
1 month.
From the end of the month in which the reply was received.
Yes.
That's the statute.
That will be that will be
31st July now.
Yes.
If what he says is right, that he had filed his reply
Yes.
in June to end of July. Right? By end July, you had to pass an order.
Yes.
You somehow stretched it to say, I gave him more time and he filed something on 24th August. He said, I never filed anything on 24th August.
Yes.
So he says, if you have to show that I never filed anything, please ask him to produce a record.
That you have to produce. You have to demonstrate it. It's a writ of certiorari.
I'll clarify.
No, it's a writ of certiorari. You have to produce. Then my lords may kindly take up
Item 87.
with your lordship's kind permission. If your lordship is not at all feeling inconvenience, I will request your lordship to take up WPC 26752.
Three metallics. Correct.
My lords, here
also replies not that.
A notice was first issued.
In none of these matters, your replies are not on record. So what have you done? We don't know.
Today, these are filed tomorrow. Today, my lord. Course of the day, it was filed.
That's the problem.
My lords. For that, I am.
Mr. Rai is more fortunate.
Yes. I am always unfortunate.
No, more fortunate. You got a reply, we don't have it. All right.
Yeah, I don't want to put you in inconvenience. If I can take your lawsuit to some few, lawsuit will kindly see.
Here also, order copy is 1589.
Yes. 28.6 is the reply of the petitioner, Annexer 4.
And the order is on 28.9.
28.9.
Correct. So in both these, you'll have to produce a record.
Yes.
Direct need point. Can you do it as a question?
Left in this batch. It is very interesting.
To file means you have to file. So when you come to SSC, even to where there's so many times you don't even grant him time. So this is Parliament fixing time.
Yeah.
Yeah, that's correct. So that you can see
request your lordships to take up item WPC 23880 item WPC Ambika Iron.
Correct.
Yes, my lords. Lordship may kindly see first a notice under section 148 capital A bracketed B was issued on 30th of March. April 2022. Assessment is 1617. Reply was given on 1st of June. 2022.
Why are you giving two replies? Annexure 5 is another reply.
Another notice was issued, my lords, that your lordship will kindly see where the scope in the statute that you go on issuing, because the statute is there. You go on issuing notice. You will go on filing reply or objection, and you will go on. There will be 148A(d).
No, there is a, yeah, correct.
How can it look?
The subject is subsequent proceedings with reference to 148AB.
All innovations.
Yes. Minus computer, there is advantage and disadvantage.
Page 30.
That's why e-filing, there's an advantage.
Paste.
No, e-filing also, there's advantage and disadvantage.
That's all, my lords. And this rest, they are also, you have to produce the records, my lords. That's what I request your lordships. Here also, why the second notice was issued? Who is compelled? What compelled?
So we'll have this tomorrow or when? When will you produce record?
Produce recording for production of records, my lord, I require more time. But here, my lord, the issuance of second notice, that doesn't.
It is couched in the same language.
To my
see the first notice, 30th of May, and the notice later on which they have issued. In the same, it has been couched in the same language.
Once opportunity is given and a reply has.
How many? He says, don't give me so many opportunities. That's no problem.
That should be within.
You give me one opportunity, that's enough, he says.
Yes.
That should be within.
After that, you're giving yourself more opportunities, not him.
Lordship may kindly say that records to be produced in all these things. Then unless there is a direction, my lords, they will not produce.
All right. But that three of these matters are different from the first.
Yes. 84. Sorry.
So Noagaon is
85. Tarini Auto Spare, my lords.
Ambika Iron,
and
Sri Metallics.
And Sri Metallics. These three.
So in say in 23354, 23880.
May Premal, I will file an additional affidavit explaining my Lord Senior submitted. But thereafter, if
No. In your reply, you are saying that he filed a reply, at least in Tarini Auto Spares.
Yes.
You have said he filed a reply on 24th August.
Yes.
He says, I never filed any such reply. So then it becomes, you'll have to show the record of such a reply or not.
Yes.
So in 23354, 23880, 26752, one of the issues raised by Mr. Siddharth Rai, learned counsel for the petitioner in these cases, is that the order under section 148 capital A bracket D of the Income Tax Act 1961 was issued beyond the period of 1 month from the end of the month in which the reply was filed by the petitioner SSC. Full stop. The paragraph, the replies filed in each of these petitions, the department we brought in record. Stop. Further, a direction is issued to the opposite party department to produce the original record in these three cases to enable the court to examine when exactly the reply was filed by the SSC and the consequential order was passed by the department under section 148 capital A bracket D of the Act. List on. It becomes a separate batch.
Yes.
December
13th December. I have got some little difficulty. My grandson's birthday is there.
Okay.
So I'll be going to Hyderabad. Can it be before that date, any date?
Or after, before that, is it?
Yes, 8th December or
9th December.
9th December.
But 9th is a Friday, so that's a problem.
8th, 7th, anyone.
What about 1st December?
1st December, man.
1st December.
Much obliged, man. Stay to continue, man.
Stay to continue. All right. So that other one, Nuagaon, 3 tomorrow.
Yes, tomorrow. There, my lords, Punjab Haryana High Court, frankly speaking, my lords, totally demolished.
Can't respond because we don't have a copy.
That's right. I'll hand over all the.
All right. 83 and 84, correct.
Item number 90.
Yes. 90, your lordship are filing the additional affidavit.
Lordship, may kindly see the order dated. Sorry. 7/3/2022. Lordship, may kindly see. Order. I'm just assisting the court. Yes, I know.
Here to assist.
Yes, very good. Both joint assistants. 7/3/2022. Order.
Anyway, let him explain.
Very good.
Let him explain.
Yes. Very good.
Your lordship has directed last stock agent to file an affidavit whether the ITA number 6970 CTK 94, which was relied upon by the tribunal while passing the present order, which is before lordship to consideration. I have filed an affidavit stating therein that this ITA 69 and 70 is different. And this fact I have also mentioned in appeal memo para 5, and it can be distinguishable. And thereafter, I am now placing the fact of the present case and the case which was relied upon by the tribunal, and tribunal basing on that order has been passed. But I am sorry to say that the order which has been either challenged with the High Court under 260A, I am not able to find out from the department. That I have to consider that. Now, your lordship, have the lordship in brief, the judgment is with you. Here, Mr. Rai has already handed over to you previous occasion.
If your lordship has the earlier orders,
we have the orders, all the orders.
The earlier orders, the earlier 69 and 7.
Oh no, that you can do. The IT 80 is earlier orders.
Yes, you know. Before lordship going to the judgment, you will kindly have a glance running page 35 appeal memo, internal page 14 of the Travis order. Para 22.
Page
running page 35, internal page 14 of the tribunal order, which is annexed to my appeal memo.
Right.
Annexure 3.
Yes, identical issue.
Yes. Identical issue was raised in assessee own case before the tribunal. IT number so-and-so for reassessment so-and-so has been decided to have the assessee holding by the coordination where that financing and adding or assisting any promotional activities of undertaking is a part of the business of the assessee company. That is the issue which was been decided by the tribunal. Here, this is slightly different. Here, the wording is compensation. And you lordship know when there is any deduction under 37 of the Income Tax Act, that is directly to the link with the business of the person who is claiming deduction.
37 is with.
Let me complete, sir. Let me complete. I am not anyway objecting, sir.
No,
I am logging from you.
Saying 37 is the business expenditure. It is not a deduction. It is.
Right. Yeah, I am.
Okay,
sir. I know that.
Very good. Very good.
Your lordship see the order which has been relied upon by tribunal, paragraph 10. 69 and 70.
Yes.
May I place in paragraph 10?
Yes.
The last issue, which is a major issue and common on both the assessment, is that loan and advance given the assessee company to its subsidiary and undertaking controlled by it having become applicable, the Commission appeal error in resolving the claim of deduction in the year under consideration of the amount of loan and advance written off. It is further contended that interest of various loan and advance having been assured under the head of income from business over a number of years. But this has been considered by the tribunal, my lord. Loan and advances, my lord. In the earlier order, that is the issue before the tribunal, whether loan and advance rendered to the subsidiary company, whether it is allowable deduction or not. That is approved, and that order has been passed. Now you will also see the order which has the order of the without not going to assessment, I cannot complete the argument. Therefore, I request your lordship to kindly running page 11, annexure 1.
Yes.
Paragraph 3.
In the course of mining.
Since ITCOL has designated on sale of ore which are authorized to be utilized by the subsidiary for sake of equity of justice, at request of managing director of so-and-so, the board of directors agreed to compensate the extra amount difference between the purchase and sale price arising out of it. So it is a compensation given to the other subsidiary unit. Therefore, my humble submission is that it is not covered by the judgment which is relied upon by the tribunal and passes present judgment. Therefore, lordship, I am relying on the
no, but this is like okay. Let's see.
Yes.
What the transaction really is.
Yes.
You're parting with money to another company, which is no longer recoverable by you.
Yes.
So the character of it being irrecoverable is common to both the 6970 and this.
Yes.
Because here it's called compensation and there it's called loan.
Yes.
It's not a recoverable loan, so it's gone.
Gone. Yes.
Here again, this compensation is gone.
Therefore, my lord, I rely on the judgment of the Supreme Court 3 judges bench.
Because you're writing off the loans and advances written off.
Written off.
So essential character of a loan and advance having been written off and this compensation, what's the difference?
Compensation, my lord, substantive is, my lord, losses. What is loss accrued by
No, they've parted with money which they can never get back. That's the character of this compensation.
Yes.
There again, loans and advances written off is the same. It's the same character.
But my lord, so far I will not understand the accounting standard. My lord, two languages totally different. So my lord, I may be wrong, my lord, but that is different. Therefore, my lord,
No, the nature of expenditure. Because if we're talking of section 37,
yes,
we look at the nature of the expenditure.
Yes, nature of expenditure, but in altogether, in the end of the day, my lord, that will not recover, my lord, end of the day.
Correct.
But the language itself says, my lord, there is loan and advance and the compensation, two different things.
Maybe, but what you're doing with it is also matters, right?
But therefore, my lord, the assessing officer and I also rely on the judgment. The third 3 judges bench, my lord. Your lordship, kindly see.
Tritanium, tritanium.
Yes, your lordship. There, your lordship, categorically not held, which is not quoted in the assessment order itself, not page 12.
Expenditure must be incidental to the business.
Yes. So my humble submission is no way related to the business, no. The separate entity, both all are the separate entity, not. Therefore, my humble submission cannot be allowed so far as the.
No, why don't we look at it? They're not complete strangers, right? It's your own subsidiary. So you're trying to bail out your subsidiary.
Correct, my lord. But we cannot beyond the statute, my lord. We have to act in accordance with the act. My lord, code, my lord, various judgments says, my lord, the taxing that it says, my lord, we cannot go beyond
this Radha Swami Satsang comes in. Basically, they're arguing Radha Swami Satsang.
Yes.
They're saying that consistency. Same SSC, 2 assessment years, you've allowed this as a deduction. How come for the remaining you're not allowing? As simple as that.
Only on the ground, my lord, the language.
There it is compensation. Here it's compensation.
That is high development. It is a compensation that is loan and advance.
Correct.
But that is the whole issue, my lord, and I rely on the judgment. My lord, I cannot develop more in this case.
Correct.
So
Direct connection you can show within a holding subject. Intimate connection.
That is what I cannot do.
All right. Anything else, sir?
Nothing. I will just bring to your lordship's kind notice. Para 20, page 34 of the tribunal order. Undisputedly, the object of ITCAL for setting up Kalinga Iron Works Limited was to improve administrative efficiency for promotion of industrial development in Orissa. The objective and purpose of incorporation of Kalinga Iron Works Limited is enshrined in the memorandum of association available at page 56 to 63 of the paperwork.
Sorry, where are you reading?
Sir, it is at page 34 of the brief submitted by
internal 13.
Internal page 13 and para 20 members. Yes. My lord got it.
In the earlier.
No, undisputedly, the object of ITCAL.
Yes, yes. Correct.
For setting up Kalinga Iron Works Limited
Yes.
was to improve administrative efficiency for promotion of industrial development of Orissa. The objective and purpose of incorporation of Kalinga Iron Works Limited is enshrined in the memorandum of association available at page 56 to 63 of the paperwork. Then the tribunal has quoted the objectives of the then para 21 matters. When we examine the memorandum of association available at page 56 to 62 of paperwork in totality, it leads to irresistible conclusion that Kalinga Iron Works Limited has been incorporated limited company to provide overall autonomy in order to improve the overall efficiency within promote and establish industry in Orissa and to further accelerate the industrial development. We cannot pick one objective as has been done by the AO/CIT appeal to work out the object of the company. Rather, we have to examine the objective in entirety. Then, my lords, para 24. Para 24, may I place your lordship the relevant portion? So, when the modus operandi of the ore transaction which resulted in ore compensation has not, lordship got it?
Yes.
Has not been changed or disputed by the revenue, the SSC company as well as Kalinga Iron Works Limited are jointly and exclusively working for promotion of industrial development. That's all. So,
all right.
Identical, only for different assessment years.
Right.
Policy.
The present appeals by the revenue are directed against the common order dated 26th April 2017 of the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack. In ITA numbers, we call the corresponding for the assessment years bracket A-wise 2004-05 to 2009-10, is it?
Yes.
2009-10. While admitting the appeals, on 18/12/2019, The following two questions were framed for consideration by this court. Take from that order. Paragraph. This court has heard the submissions of Mr. T.K. Satpathy, learned senior standing counsel for the department, and Mr. Siddharth Rai and Mrs. Amirat, learned counsel appearing for the respondent SSC. Paragraph. The background facts are that the SSC during the AYs in question debited a certain sum to its profit and loss account towards compensation paid to its two subsidiaries, that is Messrs. Itcol Kalinga Iron Works Limited (bracket IKIWL) and Messrs. Itcol Ferrochrome and Alloys Limited (bracket IFCAL) towards difference in the price of ores purchased by the above subsidiary companies from the SC and from others. Paragraph. During the course of assessment, the respondent SSC was asked to explain the above payment of compensation, single quotes of compensation, to the two subsidiary companies. Stop. The explanation offered was that two mines operated by the SSC were taken for captive use, and this would assure cheap raw material supply to ensure the long-term viability of the subsidiary companies. Full stop. Once it was found that the ore available in the said mines were not suitable for use in production of high carbon ferrochrome, the ores were then sold in open market, and ores of desired grade and specification were purchased from outside parties. Full stop. This resulted in substantial financial loss to the subsidiaries, and it is this loss which was sought to be compensated by the SSC. Paragraph. The assessing officer did not accept the above explanation and disallowed the claim of expenditure on the ground that it was not incurred, open quotation, wholly and exclusively for the purposes of the business of the unquote of the SSC. In arriving at this conclusion, the AO relied on the decision of the Supreme Court in Travancore Titanium Products Limited versus Commissioner of Income Tax, AIR 1966 SC 1250, where it was held that as under, take the whole of para 7, A to A. Paragraph. After the Commissioner of Income Tax bracket appeals, dismissed the appeals filed by the SSC. It approached the ITAT, which has, by the impugned orders, allowed the SSC's appeals. Full stop. Inter alia, in the impugned order, it was noticed in para 22 as under. Reproduce para 22, page 35. Paragraph. On 24th August, on 20th April 2022, when these appeals were heard, a query was posed to Mr. Satpathy by the court whether any appeal had been filed by the department against the orders of the ITAT. In the appeals ITA 69 and 70 bracket CTK of 1994 filed by the SSC for AYs 1989 and 1990-91. Full stop. Paragraph. An affidavit has been filed by the department today in which it is sought to be contended that the aforementioned order of the ITAT for AYs 1989-90 and 1990-91 is distinguishable on facts. Full stop. It is pointed out, it is sought to be submitted that in the said order of the ITAT, the issue concerned payment of making of loans and advances by the SSC to its subsidiaries, which were then subsequently written off. Whereas in the present cases, what was paid to the subsidiaries was single quotes, compensation, unquote, for supposed business losses of the subsidiaries. Full stop. In addition, Mr. Satpathy draws attention of the court to para 5 of the Memorandum of Appeal, where again it is pleaded that the facts concerning ITA numbers 69 and 70 /CTK 94 are distinguishable, and therefore the said order can have no application to the facts of the case. Full stop. Mr. Satpathy further informed the court that he had no information about any appeal having been filed at this court against the order of the ITAT in those in ITA numbers 69 and 70 /CTK 94. Paragraph. This court has perused the order of the ITAT dated 25th September 1997 in ITA numbers 69 and 70 bracket CTK of 1994. Full stop. The said appeals were filed indeed by the very same SSC, and the issue concerned expenditure made by the SSC for its subsidiaries in the form of loans and advances, which were subsequently written off. Full stop. There again, the issue was whether the such amount could be legitimately claimed as an business expenditure within the purview of Section 37 of the Act. Full stop. After the AO and the CITA had disallowed the said amount, the SSC approached the ITAT. Full stop. Among the reasons that weighed with the ITAT then for allowing the claim of the SSC. Was that, let's see, need to be. In arriving at the above conclusion, the ITAT relied on the decisions of the Madras High Court. The CIT versus amalgamations 226 ITR 188, is it Madras High Court or?
Yes.
In CIT versus amalgamations private limited 226 ITR 188. CIT versus Gillanders.
Madras High
Arbunot and Company Limited 138 ITR 763.
CIT versus Gilander. Your lordship is referring to this judgment.
No, amalgamations.
That's different. Yes, that is Madras.
And SN Private Limited versus CIT.
Supreme Court. That is Supreme Court, Your Lordship.
Supreme Court, all right.
We have this.
So CIT 65 ITR 625.
Yeah, only.
Paragraph. In the present case, while the nomenclature used for the expenditure incurred may have differed during AY's 1989-90 and 1990-91, where it was single quotes, loans and advances, unquote, which were subsequently written off. The fact remains that it was an irrecoverable expenditure as far as the SSC was concerned. Stop in the present AYs as well. What is paid as single quotes compensation, unquote, by the SSC to the very same subsidiaries for the business losses of the subsidiaries was again irrecoverable as far as the SSC is concerned. Full stop. Considering that the expenditure is in the nature of monies advanced to the subsidiaries, it cannot be said that there is no intimate connection between the SSC and the two subsidiaries as far as the business activities are concerned. Full stop. In that sense, the decision of the ITAT to allow the expenditure cannot be said to be inconsistent with the dictum of the Supreme Court in Travancore Titanium Products Limited, Supra. Full stop. It must be held that the expenditure incurred by the SSC in the present cases is not only incidental to the business of the SSC, but is necessitated or justified by commercial expediency. Full stop. Consequently, the court is not persuaded that the ITAT has in the present cases committed any legal error in answering the questions framed in favor of the SSC and against the department. Paragraph. As far as the present appeals are concerned, for the reasons aforementioned, questions 1 and 2 are again answered in favor of the SSC and against the department. The appeals are accordingly dismissed. But in the circumstances, no orders to cause.
Lordship may make it reportable because there is no judgment of this Honorable High Court on this point.
All right.
So
There
it
is no
should-
judgment.
Okay.
No judgment.
All right.
The Lordship may make it. Another request to your Lordship is, I'm not feeling well. So what I pray, my lords, I've got certain cell tax revisions in the second list. That's the item 45, 69 and 50.
Okay.
95. May I pray, Lordship may take it tomorrow or day after?
It will stay on the board.
Man.
It is on the weekly, that other list. Sapangari smell.
Item number 81.
Millard, shall I place that short note?
Yes.
Millard, this is a Government of India company. Lots of recall.
Can I
Last
say-
British company to leave India in 1970.
Right.
Can I pay a copy? Can I copy of the?
Yes, let's give it. Already it's there in the record. Check.
No. Check up. Not there. I've seen. Written note to copy.
But we have given you, so we don't have one extra now.
Okay, it's okay. You can argue. Thank you.
Okay. So, my lord, two Scottish gentlemen, one Mr. George Bernard Balmer and one Lorry, Alexander Lorry, came to Calcutta in 1967, started this company, which had 70 businesses when they left India. It's a mini Navaratna company now. Well, the Government of Orissa Finance Department issued a SRO unsorted under Section 6 of the Orissa Sales Act, brought amendments to Finance Department Notification numbers 1/76 for granting sales tax exemption to the all refinery unit of IOCL at Paradip. Indian Oil Corporation executed MOU with the Government of India, Orissa, for putting up an oil refinery project at Paradip in the state of Orissa, involving investment of more than 5,000 crores to generate large-scale employment. In the MOU, Government of Orissa assured, committed to provide land, water, sales tax exemption for the project. The package of incentives includes exemption of charge, levy, and payment of octroi, entry tax, or terminal tax, or any other tax of a similar nature. However, so designed, they have thought of that this may change on the entry of materials, machinery, and equipment required for construction of the project. Exemption from the charge, levy, and payment of sales tax as defined under Clause A above on materials, machinery, and equipments or any other purchases required for the operation and maintenance of the project refinery for a period of 11 years from the date of commencement of commercial production. Exemption from the charge, levy, and payment of the tax on works contract or sales tax on the transfer of goods under works contracts or other similar tax are designated on the construction of the project. 7604. Notification under Section SRO number so and so, the Finance Department issued under Section 6 of the Orissa Entry Tax Act, exempted entry tax on machineries and equipments and other settled goods required for a construction of the refinery project. Then IOCL floated tender inviting offers for construction of civil, mechanical, and electrical installation of the refinery project. Petitioner succeeded in the bid. IOCL clearly held out in the tender documents that Government of Orissa has exempted entry local sales tax on goods to be sold to in the execution of the works contract or the petroleum refinery unit. Then 1405, Orissa Value-Added Tax 2004 was introduced in the state of Orissa, which repealed the SY Orissa Sales Tax Act 1947. Section 104(2) of the new Value-Added Tax Act provided that the repeal of the Orissa Sales Tax Act 47 shall not proceed affect in the right, privilege, obligation, or liability acquired, accrued, or incurred under the repealed act. 75/2005, in spite of the aforesaid provision under Section 104(2)(c) of the Orissa Value-Added Tax Act and the exemption notification under section 35 HHH of the Sales Act, officers started demanding tax to the personnel. Personnel sought clarification from IOCL by letter dated so-and-so, and IOCL clarified that the exemption granted under Orissa Sales Act shall be continued under value-added tax. In the high-level review meeting on the implementation of IOCL project, under the chairmanship of the Chief Minister of the Minister of Finance, the following decision was taken. For smooth implementation of the project, the exempt tax on the works contract as under Orissa Sales Act needs to continue. Accordingly, suitable notification under Orissa VAT Act 2004 may be issued with the approval of the Cabinet. The state government will honor other commitments as incorporated in the MOU signed with the Messrs. IOCL, keeping in view the requirement of the project and statutory provisions in force. During 2005 and 2008, IOCL continued to pursue with the government of Orissa for issuing necessary notification under the VAT Act for continuing the exemption granted under S12 Orissa Sales Act for the goods sold IOCL in course of works contract. Exercising power under section 17A of the Orissa VAT Act 2004, state government exempted the goods sold in course of execution of the works contract to IOCL from payment of tax payable under the provisions of VAT Act. 13/2009, another notification SRO number so-and-so, under the VAT Act, government exempted purchase of goods by IOCL from payment of tax for a period of 11 years from the date of commercial production. 5/9/2009, before the notification dated 13/1/2009 was issued, petitioner had already completed the contracts, jobs required during the period 2005 to 2008 and 9, and a sum of rupees 1,20,000 had been deducted at source and was deposited towards VAT under compulsion to complete the project, and petitioner had already made assessment under section 39 of the VAT Act. A tax audit was conducted in which the department found all the account of the petitioner in order, and the audit officer recommended for the refund of rupees 1,20,000 petitioner had deposited through TDS towards VAT during the relevant period, on the grounds that the transfer of goods to the execution of the work contract by IOCL is exempted from payment of tax. Since all the account transactions of the petitioner was found to be in order and the refund of the tax recommended in the audit report, petitioner requested the sales officer to pass formal order directing to refund of the tax deposited. Though there is absolutely no question of suppression of purchases or sales or both, erroneous claim of deduction, evasion of tax, or any irregularity, and as per the audit report, refund is recommended. Without any authority of law, the sales officer conducted the audit under section 42 of the Act and passed order on the basis of best judgment assessment and demanded rupees 2,66,26,000 at tax and a sum of rupees 5,32,53,000 towards penalty. The sales officer demanded tax on the ground that there was no exemption to IOCL under the VAT Act. Then my submissions. Millard. Well, I'll just so accept these two. This is my second ground that he doesn't assume. There is no scope for assuming jurisdiction under 42. If there's a clear-cut area report accepting all my books of records, all ITC, everything that was given by me, and he recommends for reform, then no scope under the law for assuming jurisdiction. But that's my second point. My first point is this. That the exemption granted under Odisha Sales Tax Act, continued under that continued. That is protected.
Yeah.
And
104(2).
So, I also coming to that judgment I had showing my lords the other day, the counter affidavit filed by IOCL, because the intention of the government or the intention of the parties in a situation like this, whether they want it to continue or they want to discontinue, or along with the subsequent notification, is from the conduct of the parties. Which way they held out, because the Southern Petrochemical Judgment Mallet has extended it, Justice Sinha and Justice Karju's judgment, they have extended that in this kind of a situation, promissory estoppel comes to picture, legitimate expectation comes to picture, because this 5,500 crore project today, as on date, it stands at 12,000 crore. It's still going on. contractors are working now also in that project. I'll just take your lordship to the counter affidavit of IOCL. They will show it, but I want to still, I'm depending on it very strongly, my lords. Kindly see its annexure BY4, page 17, IOCL's counter, annexure BY4. This is in 2004, my lords, because that exemption was given in 2002. Page 17 of IOCL's counter. Page 21. Article 2. Packages of incentives government Orissa held out to IOCL. Orissa government will give IOCL or any other legal entity ultimately shut up to take over the project and or to resultant refinery an interest-free loan equivalent to the sales tax pay.
Page is not matching.
Page 21 minutes. Page 21. Page 22.
Package of incentives.
Minutes. Page 22. Let's see. Page 22, item 2. IOCL or the alternative entity and of the project and the resultant refinery will be exempted from the payment of the following taxes, duties, and charges mentioned below with reference to each. The exemption from the charge, levy, and payment of censure sales tax or turnover tax on the products of refinery. Got it, Miles? Page 22, item 2.
Article 2.
Miles, page 22, item 2. 2.1. Exemption from charge, levy, and payment of censure sales tax, turnover tax on the products of refinery for a period of 30 years from commence of the commercial production at the refinery. Exemption from the charge, levy, and payment of octroi, entry tax, terminal tax, or other tax for a similar nature, however designated on crude oil refinery by exemption from the charge, levy, and payment of next page, page 23. Exemption from the charge, levy, and payment of octroi, entry tax, or terminal tax, or any other tax of a similar nature, however designated on the entry of materials, machinery, and equipment required for construction of the project. Exemption from the charge, levy, and payment of sales tax as defined under clause 1A of above on materials, machinery, and equipment or any other purchases required for the operation and maintenance of project refinery for a period of 11 years from the date of commercial production. Exemption from the charge, levy, and tax on works contracts or sales tax on the transfer of goods under works contracts or other similar tax, however designated on the construction of the project. Then, my lord, can also see another MOU. This is after review after VAT Act came. When they did not issue a notification, contractors are complaining on the pressure of the sales tax department. Another important meeting, my lords, page 31. Minutes of discussion affecting implementation of Paradip Refinery project of Mr. Indian Oil Corporation held under the chairmanship of Honorable Minister of Finance, Orissa, on 29/5/2006. After detailed discussion, page 31, my lords, annexure D/4. If Messrs. IOCL have made any deduction from bills of the contractors towards TDS on last contract, the same should be deposited in the state government account without further delay. For smooth implementation of the project, the exemption of tax on works contract as under Orissa Sales Tax Act needs to continue. Accordingly, suitable notification under Orissa VAT Act 2004 may be issued with the approval of the cabinet. The state government will honor the other commitments incorporated in the MOU signed with the IOCL, keeping in view the requirement of the project and the statutory provisions in force. The IOCL in turn should ensure that the work is started in time and complete. So this is the way they have held out time to time what they intended for, so far the exemptions are concerned. And these they carried out in 2001 under section 17A of the Act. So only thing during this intermagnum period, whosoever contractor has executed, they face this problem. Their stand remains throughout that we have
Your Lordship must also see Article 5 and 7 of that MOU. I am appearing for IOCL, my lord. That at page 25, Your Lordship may see the Article 5 and 7 also.
Right.
May I read, Your Lordship? Let my learned continue. Complete that afterwards.
Promptly issue any additional notification.
Lordship. And 7, they have said that the promissory and obligation of the state government as herein contemplated shall remain unaffected.
Affected or undiminished.
Undiminished by any change in the industrial policy as well as tax policies.
Yes.
Miller. Then Lordship, see, true to their promise, they brought a notification, but maybe red tapeism or bureaucratic delay. They brought ultimately in 17A in 2009, my lords. A language is same. Language is same that I'll just replace it, my lords. Once stick 2008, they brought this notification. Power of government to exempt tax in public interest, notwithstanding anything contained in this act, the government may, if it's necessary to do so in public interest, subject to such conditions and exceptions as it may impose by notification, exempt any specified class or sales or specified sales or purchases from payment of whole or part of the tax payable under the provisions of this act. Every notification issued under the subsection 1 shall as soon as before the assembly. Now under this 17A, my lords, they issued a notification for IOCL. Annexure 6, my lords. Annexure 6 of my reproduction, page 25, my lords.
Yes.
In exercise of the powers conferred by Section 17A of the Orissa Act 2004, in state of the state government having been satisfied that it is necessary so to do in public interest, do have exempt the goods as goods and other form sold in course of execution of a vast contract to Indian Oil Corporation Limited, Paradip Petron Refinery Project located in the state of Orissa at Avachandrapur in the district of Jagatsinghpur from payment of tax payable under the provisions of the said act on the following conditions. Namely, then they say for how many 11 years from the date of commercial production. Then the next notification they took out for entry tax. So here they completed, they thought their commitment, but what has protected me is 104.
Savings clause.
104.
Savings clause.
Same act. 600. Miller. 104 to C matters.
Yes.
The repeal of the Orissa Sales Act,
Yes.
1947, hereinafter referred to as the repealed act under subsection 1, shall not, we'll go to C statement, affect in the right, privilege, obligation, or liability acquired, accrued, or incurred under the repealed act. That is Sales Act matters. We run this C matters. And I had shown you, Lordship, extensively that a southern petrochemical case where in a repealing statute, similar provision they had, interpreting that or reading that with section 6 of the General Process Act, Honorable Supreme Court, referring to all previous judgment of the Supreme Court, have said that in this case, even if this provision is not there, still section 6 of the General Process Act will come to the rescue unless there is a contrary by conduct of the parties that they completely want to do away with the exemption. I had placed it, that judgment before me, Lord. So I think I have to repeat again some of the paragraph if Miller just Raman was not there.
Correct.
You also may recall because Lordship has already marked some of the paragraph in that.
Correct.
I'll go to paragraph 24. Paragraph 24, Southern Petrochemical. Lordship, see, it's there in my Lord's record.
Yes.
Southern Petrochemical versus electricity inspector. But in this particular act, 2 enactments of state of Tamil Nadu were repealed. Paragraph 10. In the year 62, the state of Tamil Nadu enacted Tamil Nadu Electricity Taxation and Consumption Act 1962 to provide for the levy of tax on consumption of electrical goods.
That's what
Then, Section 12 provided for exemption. Paragraph 13. On energy consumed subject to some conditions measures. Section 13 of 62 Act, however, enabled the government to make exemptions and impose restrictions by notification in the following terms. There was in 1939 Act and 62 Act, both were repealed by the Act of 2003, paragraph 16 of that judgment. Incidentally, the 2000 Act was not to consolidate and amend the levy of tax on consumption or sale of electricity, but to consolidate and rationalize the same. Then, my lord, in that they had this provision. Section 19, paragraph 19 says, my lord, Section 14 of the 2000 Act provides for general exemption, which in the following terms: exemption and reduction of tax. Government may by notification make an exemption or reduction in rate in respect to electricity tax payable under this Act and on electricity sold for consumption by or in respect of any person, individuals. Then, my lords, next page, page 9 of the judgment, the repeal and saving clause is contained in Section 20. Language is same. Any right, privilege, obligation, liability acquired, accrued, or incurred under the said Act. Now, see Section 20 and Section 21. Section 20 and 21 of the 2003 Act result under Section 21. The Tamil Nadu Electricity Tax also and Act 62 is hereby repealed. The provided that such repeal shall not affect any right, privilege, obligation, liability acquired, accrued, or incurred under the said Act. This came to be interpreted by the High Court there. Then it came to Honorable Supreme Court. Then now, Lordship, will come to page 24, my lords. Page 24. Page 24.
Yes.
Paragraph 8 of the judgment. Section 20 of the 2003 Act repeals the 62 Act as well as the 39 Act. The effect of repeal is well known, wherewith there doesn't appear to be any general controversy. Thus, before proceeding to avert to the rival contention of the parties, as noticed before, we may notice certain precedents of this court operating in this behalf. Where a similar clause has been interpreted by the Honorable Supreme Court, that all judgments, I'll just play this first one pass. State of Punjab versus Mohan Singh. Whenever there is a repeal of an enactment, the consequences of laid down in Section 6 of the General Clauses Act will follow, unless as the section itself says a different intention appears. In the case of a simple repeal, there is scarcely any room for expression of a contrary opinion. But when the repeal is followed by fresh legislation on the same subject, we undoubtedly have to look to the provisions of the new law, but only for the purpose of determining whether they indicate a different intention. The line of inquiry would be not whether the new act expressly keeps alive old rights and liability, but whether it manifests an intention to destroy them. We cannot therefore subscribe to the broader proposition that Section 6 of the General Clauses Act is ruled out when there is a repeal of an enactment followed by a fresh legislation. Section 6 would be applicable in such cases also.
Well, yes, the line of inquiry would be.
The line of inquiry would be not whether the new act expressly keeps alive old rights and liabilities, but whether it manifests an intention to destroy them. We cannot therefore subscribe to the broad proposition that Section 6 of the General Clauses Act is ruled out when there is a repeal of the enactment followed by a fresh legislation. Section 6 would be applicable in such cases also unless the new legislation manifests an intention incompatible with the contrary to the provisions of the section section. Such incompatibility would have to be ascertained from a consideration of all the relevant provisions of the new law, and the mere absence of a saving clause is by itself not material. It is in the light of these principles that we now proceed to examine the facts of the present case. And here there is a saving clause. Here there is a saving clause. And for the intermagnum period, if anyone argues that first act came, second act did not have any provision for exemption till 2009, till section 17 incorporated. If anybody makes that argument, the answer is this stares at us that we have to read it and see the intention.
Right.
Then, my last, page 25.
Yes.
Page 25, that famous T.S. Balia case, Lordship knows. Paragraph 92.
Yes.
In T.S. Balia versus T.S. Rangachar, income tax officer, Central Circumstantial. The principle of this section is that unless a different intention appears in the repealing act, any legal proceeding can be instituted and continued in respect of any matter pending under the repealed act, as if that act was in force at the time of a repeal. In other words, whenever there is a repeal of an enactment, the consequences laid down in section 6 of the General Clause Act will follow, unless, as the section itself says, a different intention appears in the repealing statute. In the case of a simple repeal, there is scarcely any room for expression of a contrary opinion. But when the repeal is followed by a fresh legislation on the same subject, the court would undoubtedly have to look to the provision of the new act, but only for the purpose of determining whether they indicate a different intention. The question is not whether the new act expressly keeps the old rights and the liabilities, but whether manifestly...
It's a repetition.
It's a repetition. Then let's see the next page. That Gajraj Singh case, paragraph 90.
I don't think we need to go through again.
I'm obliged.
Let's hear him. Let's hear the other side.
Yes. The judgment I'll go to answer the judgment later on. Your Lordship may kindly turn to the prayer. In the entire prayer, Your Lordship, the petitioner challenged the order of assessment, and Your Lordship may kindly turn to the order of assessment, the relevant portion. And the relevant portion is at page 37.
Yes.
Wherein it has been categorically stated that since in absence of notification, Your Lordship, all the assessment has been done, Your Lordship. Your Lordship, in the paragraph, page 37, gone through the observation of the auditing vis-a-vis the document filed by the learned advocate of the dealer company and the concerned finance department notification bearing number 46 stated 14/1/2019 9 of the Government of Orissa, and found the dealer has received all the payment against the work executed prior to the above notification. So the exemption provided by the notification of the finance department of the government.
Treating the notification as prospectus.
Now, Your Lordship, so far as the exemption notification. Now, Your Lordship, how the exemption notification for the year 2004 has been issued as per section 6 of the Orissa Sales Tax Act, Your Lordship. Section 6 of the Odisha Sales Tax Act, Your Lordship, says the state government may, by notification, subject to such condition and exceptions, if any, exempt from tax the sale or purchase of any goods or class of goods, and likewise withdraw any such exemption, Your Lordship. This is section 6. And as per section 6, all the exemption notification, including, Your Lordship notes that IPR exemption, everything has been issued pursuant to this 6 provision of section 6. Now, Your Lordship, what is the provision so far as the VAT Act is concerned?
17 calculated.
No, Your Lordship. Lordship, section 6 grants the exemption, including IPR, and the repeal and saving clause is not applicable here, Your Lordship. Your Lordship may kindly turn to the provision of section 106L. 106, Your Lordship, 106(2), subsection 2, clause L, Your Lordship. Because what happened during the VAT Act, Your Lordship, just introduction, Your Lordship, let me give the introduction. When the Odisha Sales Tax Act has been repealed and the VAT has been introduced, what is the difference in between Odisha Sales Tax Act and Odisha Value Added Tax Act? Because in the Odisha Sales Tax Act, exemption was granted. In the Odisha Value Added Tax Act, including that white paper, your lordship, input tax credit, a new system has been generated, input tax credit in the Odisha Value Added Tax Act. And while Odisha VAT Act has been implemented, it has been decided by the government not only in the state of Odisha but all over all the states of India that the exemption will be deleted, your lordship. Now, your lordship, may kindly 106. A registered dealer, shall I place your lordship? A registered dealer who was eligible to the benefit of or was entitled to exemption from payment of tax on purchase of raw material, spare parts, packing material, sale of its finished product under the repealed act on the day immediately before the appointed day shall on and from the appointed day be allowed the benefit of deferment of tax in lieu of such exemption, subject to such restriction and condition as the government may by notification specify in this behalf. Since a specific provision, your lordship, my respectful submission before your lordship is that since a specific provision has been inserted by the government as section 1062A, hence for this purpose of exemption, granting of exemption, the repeal and savings clause is not applicable, your lordship. So what for section 104 2C is applicable? 104 suits 2C is applicable where after any right, privilege, obligation, or liability acquired or accrued or incurred under the repeal act. Here, your lordship, the exemption is not a right. The exemption is not a privilege, your lordship. The exemption is only what the settle of that exemption is not a vested right. And hence, exemption under West Act is not saved, your lordship, as per this repeal and savings clause, your lordship. Now, your lordship, so far as section 17A, as like as section 6,
No,
6 was
106, it says transitional provisions, right?
Your lordship, 106
This
2L. So, as
2A is what? 2 capital A.
2L, L, your lordship, L for lion.
Right.
The last subclass of 1062, the last subclass, just over 107. And this is well aware about the petitioner because petitioner has given the submission before the assessing officer that this provision is applicable to him. So a deferment may be allowed to him.
No, what's the meaning of deferment then?
Your lordship, deferment in the sense for the specific period, the tax is exempted means deferred, and after conclusion, your lordship, he has to pay the tax. This is the also.
I'm not clear.
No, it is not deferment. Deferment is collect now and pay later.
Pay later. You collect. This is since the value added tax act.
He's paid. He has already paid the. He's already deducted and already paid.
Not paid.
Yes. He's paid already 1 crore.
Only a specific amount. Not the total amount.
Supposed to collect anything else, sir.
Your lordship may kindly look in the assessment order.
He is not collecting anything.
After this notification exemption came, 2009 onwards, he was not supposed to pay anything at all.
Already work over.
Before that, he has already collected and already paid. He has paid 1 crore and something.
Your lordship, 1 crore and something has been paid. Your lordship, that has been deducted and paid. But during that particular period, your lordship, he has not paid. Because there is no notification, your lordship.
No. I think you got your facts wrong.
Your lordship, I may be. Your lordship, what happened?
He continued deducting tax at source and he continued paying.
No, your lordship. That is not so. Your lordship, he has deducted the tax prior to 1/4/2005 and which has been paid. 1/4/2005, he has not collected. After 1/4/2005, for a particular period, he has collected. But for the entire period, your lordship may kindly turn to the assessment order. The quantum of page 36. Here 3 crores, your lordship, the excess amount is page 38, relevant page. The total tax, your lordship, TT, the balance is 11 crores, is calculated at 3 crores, 22 lakhs is the tax. And he has deposited, your lordship. So the balance has been raised as a demand. And your lordship, the petitioner himself has written, your lordship may kindly turn to his representation. His representation is at
no, but how do you say under 104.2, it's not a right, is it?
Your lordship. Miller, let me. Then just let's clarify this. Let's clarify this first. Lordship, kindly, Miller, para 100, 190 of the judgment, Millers, of the judgment. What Supreme Court said. We are also unable to agree with Mr. Ayodhya Ranjan that exemption of tax is a mere concession defeasible by government and doesn't confer the accrued right to the recipient. A right of exemption with a valid notification issued gives right to an accrued right. It's a vested right. Such right had been granted to them permanently. Permanence would mean unless altered by a statute. This is paragraph 108, 109. Please wait. You said it, let me answer. Thus, when a right is accrued or vested, this same can be taken away only by reason of a statute and not otherwise. Thus, a notification which was duly issued would continue to govern unless the same is repealed. And what repeal act is, here they deal with the repeal act.
Only question is, this 104.2 C has to be read with 106.2 L. The question is, can we disjunctively read it? Because 106.2 L seems to specifically deal with this exemptions.
And I think 108 L.
106.2 L. You can reply in your turn.
I will then.
Because you have to address that 106.2 L. Yes.
Your Lordship. This aspect also, the petitioner himself has stated at Annex 5, Your Lordship, page 21. To the commissioner, he has requested at page 23, the relevant portion is at page 23. That section 1061 of the VAT Act provides a registered dealer. The petitioner himself has narrated. A registered dealer who was eligible to the benefit or was entitled to exemption from the payment of tax and purchase of raw materials, so on, so. A reading of the aforesaid provision make it clear that a registered dealer who was entitled to exemption from payment of tax and on the day immediately before the day be allowed benefit of deferment of tax in lieu of such exemption, Your Lordship. So for this, Your Lordship, the petitioner at the time of assessment, it has been calculated that the petitioner is liable to pay 3 crore 22 lakhs and the petitioner has paid by way of collection 1 crore 851. So thereby the balance has been raised. So by the promissory estoppel, Your Lordship, one judgment, I may be permitted to place one judgment of Honorable Supreme Court. Exactly in case of that.
I don't think he argued promissory estoppel.
No, I have not.
didn't hear him argue promissory estoppel.
That since OST,
he never argued promissory estoppel.
Since Odisha Sales Tax Act, so at any time.
His argument is very simple.
Your Lordship.
He says under 104.2C, this is an accrued right of exemption. It continues even under the OVAT Act because of 104.2C. That's his argument.
No,
he's not talking of promissory estoppel at all.
11 years.
Yeah.
106. We are talking accrued rights for IOCL. My response, Your Lordship, is that section 106.2A is squarely applicable because it is the exemption. And number 2, Your Lordship, section 17A. Your Lordship, the legislature, Your Lordship, what happened here? After repeal of the Act 1 for OST Act and section 6 of the OST Act.
Here the dealer is who? No. One is, what about IOCL? The ultimate beneficiary is IOCL, right? Because he is supplying material for IOCL's project.
Your Lordship.
And for the supply of material to the works contract which is executing for IOCL, an exemption has been granted.
Your Lordship.
So there's an exemption from payment of tax so long as the project is the IOCL project.
11 years.
At that particular period, Your Lordship, there was no exemption. Why there was no exemption? After repeal of the OST Act with effect from 1/4/2005, Your Lordship, there was no exemption notification, only deferment is there. Section 106. When the notification came, the in order to provide the notification, Your Lordship, the legislature has to give the power, and the state government is notified. Section 17A, Your Lordship, the legislature has given the power to the state government in order to grant exemption notification with effect from 1/6/2008. After the delegation of the power to the government as per Section 17A, the government issued the notification with effect from 2009, Your Lordship, that notification. And that notification is a prospective, Your Lordship. What Section 17A, the same power of the government to exempt tax in public interest, notwithstanding anything contained in this act, the government may, if it is necessary so to do in the public interest, subject to such condition and expectation as may impose by notification, exempt any specified class of classes tax payable under the provision of this act. This provision, legislature has given the power, delegated the power to the government on 1/6/2008, thereby notification. So if at all, Your Lordship, it can be, Your Lordship, then that notification of 2009 can in worst case can be retracted to 1/6/2008.
Retrospective.
2008, Your Lordship. Till delegation of power. Your Lordship, because until unless the provision to grant exemption is in the statute, Your Lordship, cannot be granted. Because it is all along a new statute. And
which is why the repeal and savings clause.
Your Lordship.
This is what 104. So
Your Lordship.
read 104 is a question.
Your Lordship, my respectful submission before Your Lordship, since 106(2)(l) is there, so here, as regards to exemption, 104 is not applicable. That is my respectful submission. And since Section 17A, 106(2)(l) is applicable, and Section 17A has been introduced, has been delegated with effect from 1/6/2008.
So in effect, then IOCL has to pay this. IOCL was enjoying the exemption, correct?
IOCL has to
because
pay.
IOCL has enjoyed the exemption,
but
they don't have to pay tax.
He is the contractor.
That's
the
right.
Contractor.
Because
He has
IOCL is
executed the
exempt from
contract.
paying tax, he does not have to pay it.
So he is the registered dealer. Petitioner is the registered dealer. Petitioner is to be assessed. So only the project is exempted. So if there is no exemption on the project, so he has to pay the tax.
No, but that exemption did continue.
No.
Yes.
No, not continue. It is a fresh exemption.
You're not reading 104, sir. You're not reading.
Your Lordship, so far that 2004 notification ends with effect from 1/4/2005. And a fresh notification, 2009 notification has come. It is a fresh notification.
No. How do you read 104 2C is the question, sir?
No, until unless it has been, Your Lordship, vested right. Exemption is a vested right. So it cannot be.
That's why he's relying on this specific judgment.
Lordship, on that judgment, Your Lordship, I have to answer on that judgment only.
You better answer.
Your Lordship, on that judgment, I
but you have to answer. You have to answer. His plank of his submission is that judgment.
Your Lordship, I have not gone.
This exemption as a right.
Your Lordship, I have not gone through the judgment.
Under the effect any right privilege, he says this is my right. Exemption is already accrued as a right.
And that judgment goes one step further, saying that it is a privilege and it is more more beneficial than the right itself.
Yes.
Right.
No, Lordship, on this aspect, now Your Lordship, on the last occasion, my learned friend was arguing so that I am new on this matter. So let me go through that judgment. That judgment is also not with my file, in my file.
So you better go through that.
So let me.
That's one of his main planks of his argument.
Your Lordship, yes. Because my respectful submission all along.
And they discuss a whole load of judgments, including the Punjab judgment and all of that.
Your Lordship.
And General Clauses Act.
Yes.
And then they say that this repeal will not affect this kind of a right.
Your Lordship, let me go through that judgment. Because so far the statute is concerned.
Only distinguishing feature which he has to answer is whether in those statutes
there was any provision similar to 106 to L.
Exactly. Already my Lord and Senior has already placed that. No. That is not
L,
there.
No.
No.
L is
Please,
not L.
please.
Let him anyway. He wants.
Let him complete. I'll answer.
So when do you want it? Correct.
Tax officer versus Sri Durga Oil Mill. Even section 6 was there.
No.
Anyway, you study the judgment before you answer. Please study the judgment.
Sri Durga has no answer for you.
Can it be answered?
Every day we have huge code.
Acha.
If you take a chance on 30th November.
Millets, from 25th to 3rd November, I'll be away in Delhi. From 3rd to 5th, immediately after 3rd of December.
Your Lordship, on 7, 8, 9, I will not be there. Your Lordship, I'm sorry. Your Lordship, on the last day also, I have requested Your Lordship in the other case. 16th December, my also anti-tax matters are there. So this can be done.
No, I'm not there. My Lord, 16th, I'm not there, my Lord. No.
I'm sorry.
19th December, you take a chance.
My Lord.
Your Lordship?
19th.
Lordship.
I'm not there. 16th Friday, Lordship is sitting on single.
No, many matters are been fixed.